This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hi, everyone. Welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed, reading through the Menendez brothers' second trial, which took place in 1995 and 96. We are currently on the defense's case, part 79. We're continuing on with our defense witness, Dr. John Wilson, who is a trauma, especially a child abuse, child trauma uh, specialist when it comes to psychology. So he is talking about different things that, different ways in which PTSD can manifest in these traumatic situations, traumatic upbringings like Eric and Lyle had. And we also heard some arguments from both sides regarding some of the PTSD stuff coming in. The judge really and the judge and the state seem to really want to keep a lot of the abuse stuff out, the PTSD stuff out, like anything that bolsters the defense's case that there was abuse. They don't want it in. So that's kind of where we're at. We're going to continue where we left off, which was uh, January 22nd. I believe it's Monday. Yeah, Monday, January 22nd, 1996 is where we're going to pick up when they come back from lunch. But first, let me very quickly thank my founding justice insiders, and that would be Toyota Girl 67, SLB 29488. May the force be with you, 4313. Jessica Weenan 6079. Mrs. Apples 2007. Butler 89833. Brooke JF. Jen P 773. Boom Chicka Wow Wow 1. Kendall B 5757. Carly 0406. Oh, Ashley 83. True crime debates, sorry. Sandy South 5706. Chicken Head 33, which always makes me laugh. This one frustrates me because I never know how to say it. Nicotio Nirotini, or something similar to that. And then there's That's So Nelly, Julie E 6770, 1-800-FRAUDBUSTERS, Bezo Jones, and Hannah Banana Bandana 23. Thank you, Founding Justice Insiders. And then to my Justice Insiders, Lainey Jane 91, Couch Potato Pro, and Tech Vibe _42. Thank you for being Justice Insiders. Now we can get to the testimony. So we're coming back from lunch. We're going to probably have a little bit of argument before the jury comes in, only because the court has to give uh, his orders, I guess, or rulings regarding whether the PTSD stuff, she can go further into it and things like that. They had arguments at the end of the day on Friday. So I'm sorry, not on Friday, on earlier in the day before lunch. I was thinking it was the day previous. So no, they went to lunch prior to this and had some arguments about the PTSD and the extent in which it comes in. Did I say that this was part 78 or 79? I don't remember. It is part 79. If I said it was 78, I correct myself. This is 79 out of, I believe we have 92 or 93 parts of the defense's case. So we're getting through it. All right. I was also going to tell you, if you don't know, there are always timestamps. So if you don't want to hear like rulings and things or arguments when the jury's not there, you can always skip forward with the timestamps that are in the description. Or maybe you were listening to some and then you had to step away and come back and you can't remember where you were. You can find it more so by like who was on the stand and stuff like that. So that could help you with your getting back to your place if you need to. All right, so let's get started here. The court says there's no jury right now. The court says the defendants are in court with their lawyers. People are here. The jury is not. Anything further on the subject that we had been discussing? Ms. Abramson says, I reread Eris, Your Honor, and I think my interpretation is correct that the court there held that a battered person syndrome, a battered wife syndrome evidence, and you don't have to be a wife, you could be a son, you could be, it's domestic type violence, a battered person syndrome evidence that Dr. Walker should have been permitted to testify that the defendant in that case, the court says, I know what those cases without reading what Eris said. Anything further to argue on the point? Miss Abramson says no. The court says, people have anything else? Mr. Khan says yes. I would just ask that counsel indicated that she is going to, in her questioning of the witness, simply ask the witness if certain types of behavior is consistent with post-traumatic stress disorder. And then she says, and I may occasionally ask the witness why he holds that opinion. So I think it's very clear that that way she's going to proceed now, or the way she's going to proceed now is she's going to blurt out imminence and fear. She's going to have the witness do it. So I would ask at this point if counsel is intending to elicit anything from the witness concerning imminence or fear, that she indicate to the court beforehand that the witness be instructed not to blurt these matters out before the jury until it has been discussed. Ms. Abramson says, I thought we were discussing it now. I think I should have a right to ask the witness whether my client's condition, as someone suffering from PTSD, could have affected his perceptions of danger and imminence at the time of the shootings, which is precisely the Eris question. And that's even more watered down than the way that it was approved of in Eris, where the indication was you could ask straight out whether the experience of the client, who's a battered woman, affected the perception. The court says, okay, let's just get through this briefly. What we're discussing primarily is Penal Code Section 229, and the holding in People versus Eris, the Penal Code is Section 29, states in the guilt phase of a criminal action, and that's what we're in right now, is the the guilt phase of this trial, and then we have the penalty phase coming up after they are found guilty. So in the guilt phase of a criminal action, any expert testifying about a defendant's mental illness, mental disorder, or mental defect shall not testify as to whether the defendant had or did not have the required mental state, which includes but are not limited to purpose, intent, knowledge, or malice after a forethought or for the crimes charged. The question as to whether the defendant had or did not have the required mental statement shall be decided by the trier of fact. That meaning the jury should decide his state of mind for that to be PTSD. Malice, a forethought, is an element of the crime of murder. By decision of the California Supreme Court, a finding of actual belief of imminent danger of death or great bodily harm in acting upon that belief eliminates the element of malice a forethought. Therefore, an expert is prohibited pursuant to Section 29 of the Penal Code from testifying that a defendant acted in the actual belief of imminent danger of death or great bodily injury. That is also the holding in Eris. In Eris, the defendant contended that the trial court erred by excluding testimony, first, that the defendant was a battered woman based on the expert psychological evaluation of the defendant, and two, explaining how the psychological impact of being a battered person or battered woman affected her perception of danger at the time that she shot her husband. Then the Eris courts went on to generally state what it was that the expert in the case was preferred to say, and characterized it in this fashion. With respect to whether the defendant was a battered person, the expert in that case, Dr. Walker, would have testified that the defendant was a battered woman based on her psychological evaluation of the defendant. And with respect to the second category, explaining how the diagnosis affected the individuals and her perceptions, Dr. Walker would have used battered woman syndrome to explain the psychological symptoms and the psychological impact of the person's state of mind at the time of the homicide. The appellate court concluded that the trial court was correct in excluding Dr. Walker's opinion that the defendant had a reasonable perception of danger, and that was for a separate reason, that Section 29 of the Penal Code. For a different reason, a separate reason other than. The perception of reasonableness is not one for the expert to resolve, but for the trier of fact to resolve. That's fine, but the expert needs to relay the fact that they wouldn't be in a state of thinking reasonably. The expert needs to be able to state that without all these objections and things. So the perception of reasonableness is not one for the expert to resolve, but for the trier of fact or the jury. So for that reason, Dr. Walker's opinion regarding reasonableness of any belief and need to act in self-defense was not subject to expert testimony, but was something for the jury to resolve. The appellate court went on to say that Dr. Walker's opinion, slightly reframed, was highly relevant on the element of self-defense, the subjective belief, the actual belief of danger, and the need to act in regard to that danger. The appellate court went on to say the relevance of the defendant's actual perception lies in opinions explaining how such a perception would reasonably follow from the defendant's experience as a battered woman. This relates to the prosecution's argument that such a perception of imminent danger makes no sense. The victim in that case was asleep and there was a way of escape. The appellate court went on to say, however, that Dr. Walker's opinion is inadmissible to the extent that the testimony that the defendant had or did not have malice aforethought, since having an actual perception that one is in imminent danger negates malice aforethought. The appellate court held that Dr. Walker was properly prohibited from stating an opinion that the defendant actually perceived that she was in imminent danger and needed to kill in self-defense. Then the appellate court went on to say it was terror, however, for the trial court. It was error for the trial court not to permit Dr. Walker to testify based on her experiences on battered woman's theory as to how the defendant's particular experience as a battered woman affected her perceptions of danger, its imminence, and what actions were necessary to protect herself. An expert's opinion of a defendant's mental state does not violate Section 29 as long as the expert does not express an opinion that the defendant did or did not have the mental state required for the charged offenses. Quote, Dr. Walker's proposed testimony that the defendant was a battered woman and how being a battered woman affected the defendant's perception stopped short of the ultimate issue of what the defendant's perception actually was and therefore does not violate Section 29. This is an area that was discussed many months ago in regard to the proposed testimony of the experts, and the court ruled that the testimony is admissible evidence in regard to the defendant's mental state at the time of the crime. So it's admissible regarding state of mind. And he's already ruled on that in the past. And at that time of the ruling indicated that there had to be some fine-tuning of the offer of evidence to conform with Section 29 of the Penal Code, that during the representation of this evidence in the first trial, to some extent, it went beyond the confines of Section 29 of the Penal Code, and some of the proposals here are, as initially phrased by the questioning of Dr. Wilson just before the break, bordered on a violation. What? So the way it initially phrased by the questioning of Dr. Wilson was borderline a violation of the Penal Code, he's saying. Clearly, Dr. Wilson is not to be permitted to express an opinion that the defendant actually feared or actually had a fear of imminent danger or acted because of those actual beliefs. But can't he say he thinks that that's how he felt? I don't know. Like, he's an expert for a reason. He should be able to testify to this. This is ridiculous that he's being banned from that. If Dr. Wilson did so testify, it's my analysis that he would be violating Section 29 of the Penal Code. But by the same token, the defendant is entitled to introduce evidence, expert testimony of the effects of the psychiatric or psychological disorder on his mental state at the time of the offense. And it's a quandary that the appellate courts really have not resolved with any great specificity. The Eris case cites 3 cases: People versus Jackson, People versus Whitler, and People versus McGowan. I've reviewed those cases. They're basically oriented to specific facts as presented in those cases, and other than some general statements, don't provide any guidance as to what specifically is permitted in this factual situation presented to this court. Likewise, the Eris case doesn't, because it never dealt with the actual testimony that was received. It only talked in general terms about the evidence that should have been received and was not received. So the court is faced with confining the expert's testimony to that which is legally permitted in this state. If the legislature, if the appellate courts so choose, more likely the legislature and or the electorate so choose, psychiatric and psychological evidence in the guilt phase of the trial could be excluded in its entirety. It's certainly within the realm of constitutional analysis to exclude this in its entirety, but it has not been. This evidence, to a certain extent, is controlled by Section 29, and to a lesser extent, Section 28 of the Penal Code is still admissible. So the court is faced with a balancing here of preventing an expert witness from going beyond what is permitted, but still allowing the defense to present its defense, and to present its expert testimony to permit the jury to consider the expert testimony, the diagnosis provided by the expert, if the jury chooses to accept that diagnosis and the impact of that particular diagnosis, the symptomology of the defendant at the time the event occurred, which are relevant in this case. The proposal here is prosecution's proposal is basically to stop right now. We've gone far enough. I don't agree with that. I think that if that was so, I think we would have analyzed it much differently as far as whether or not such evidence would be admissible at all, because clearly the defense should be permitted to introduce additional evidence than that which has been offered so far without going beyond the limits of section or to the limits of Section 29. And the offer here, as I understand it, and I can't rule on the specifics until I hear the questions or asking the witness questions regarding whether or not certain testimony of the defendant, if believed, is consistent or inconsistent. The description of the certain state of mind of the defendant at a certain time is consistent or inconsistent with the diagnosis of PTSD. And that seems to me to be an appropriate area of inquiry. Exactly. That's how it should be done. And why we're even having this conversation, why this couldn't have just been decided, I don't know. And that seems, and that's what she offered too. She's like, I'll just offer it in hypotheticals and generalities. I won't say specifics that happened in this case, you know? And yet he's back to that. Like he didn't just, allow that at the time, or, he allowed them, I guess, to make all of their ridiculous arguments. Well, the state made ridiculous arguments. And that seems to be an appropriate area of inquiry. It's phrased basically along the lines of the hypothetical question, assuming that you accept the defendant's version of those events would that be consistent or inconsistent with the effects of stress disorder on an individual? The people's argument that, well, what do you do when with that in cross-examination doesn't meet the offer here? It seems to me that the defense is permitted to go beyond just the generalities that somebody has been diagnosed as suffering from PTSD, but you relate it to some case-specific symptomology the defendant described in his testimony. Otherwise, we really wouldn't have seen the testimony presented at all. It wouldn't have any relevance to the case. So I'll permit phrasing of questions along the lines of a hypothetical. Ms. Abramson says, I'm going to use the assume construct that the court just paraphrased. The court says, but the expert, again, is foreclosed from stating his personal belief that the defendant believed he was in danger. Ms. Abramson says, right. The court says that he believed he was in imminent danger or in fear, that That these are issues for the trier of fact to decide, not for an expert. So the expert can't say he was in fear, that he was acting out of fear. The defendant can say that, but the expert can't because there's no way for him to know for sure. But he can say the way that Erik was acting, the things that Erik did or said, prove or show me that he did those things because he was in fear. So that's how you have to get it in. And that's typical of, medical diagnoses and things. You have to leave the very, very offset chance that you might be wrong. So you can't say it in specifics. Anyways, so the court says that these are the issues for the trier of fact to decide, not the expert witness. And without previewing each question and answer, I'll permit inquiry along those lines with objections and rulings made as we proceed. Ms. Abramson says, what I was going to do, Your Honor, my dog is having a nightmare. Now he stops. You might have been hearing him. There he is again. He's laying on my lap. Now he stops. I move the mic so he could be the star. And now he stops. Okay, never mind. He was dreaming about something good. Anyways, Ms. Abramson says, what I was going to do, Your Honor, was just ask one sort of global question, and then when we get to the specifics of the last week being a series of hypotheticals about certain crucial points in the unfolding of those events. The court says, okay, what was your goal or your global question? She says, well, first of all, to let the jury know that he is familiar with the defendant's account of the events of the last week, and particularly of the hour or so before the shootings, that he has both interviewed him extensively about that account, that he has read his prior testimony and current testimony about it, that in all three sources the account was, well, the other two sources were consistent with what he was told. And then I was going to ask him, in fact, you cannot say as an expert witness whether or not those facts are in fact true, just to make it clear that we're doing just to make it clear what we're doing with the jury. And he, of course, is going to say, of course not, he wasn't there. And then I'm going to ask him, if you assume, therefore, that what you were told about thus and such was true, if the reaction that Erik Menendez described was consistent or inconsistent with persons suffering from PTSD. The court says, I'm not so certain. I don't know what the action is you're talking about. I'm not too certain if the actions themselves are the subject of expert testimony, but an expression of a certain state of mind. Ms. Abramson says, right? The court says, at a certain time. Ms. Abramson says, I can make it very specific. His expression of extreme fear that he was in imminent danger of being killed, consistent or inconsistent. And I wasn't going to have him elaborate on that point because then I think we have to deal with, before we get into the last week, we're going to have to go to the topic back to the DSM 4, and we have to deal with the topic of malingering before we get too deeply. The court says you can conduct your examination as you see fit. Why is he being so nice to Miss Abramson? Because he knows he's going to just object, or the state's going to object, and he'll sustain it anyways. Ms. Amerson says, yes, I just want the court to understand that we're going back to the specifics of the last week, and that's when I would ask whether, assuming the information you received about the history was true, assuming the information you received about those events in the last week is true, is this the kind of behavior, for example, that in your experience could constitute a cue, like was that cue or clue, could constitute a cue that someone with PTSD would react to with extreme fear, the kind for the actual specifics of the last week. The court says, well, I don't know if that would satisfy Section 29 of the Penal Code. If that's how you're phrasing it, I'm not going to rule on specific questions now because we'll be here for 2 days. Samerson says, right. And I may get more accurate as I move, or as it goes along, which I don't feel particularly articulate today in any way. The court says, do the people wish to be heard? Mr. Khan says, I think counsel should be admonished not to ask questions about extreme fear. She is doing exactly what I think the court is saying she should not do. I don't think we should begin unless there's at least that understanding on counsel's part as to whether she can inquire into extreme fear of the defendant. I think that she's just rephrasing the prohibition that court just gave her, and it still violates Penal Code 29. So as long as these are counsel's questions, we know she's going to ask these questions. I think we should deal with it now and not wait until the end of, uh, not wait until we get in front of the jury and she will change a word here and a word there, and essentially she's violating the court's ruling. The court says the reference to assuming the defendant expressed extreme fear would be that consistent with a diagnosis of PTSD. PTSD, is that what you're proposing to do? Ms. Abramson says, no. Would that be consistent with the effects or the symptoms of post-traumatic stress disorder that he has previously described as hyperarousal? Is that manifestation, or could that be, is that consistent or inconsistent with the hyperarousal manifests itself? I can do it that way. The court says, I think expressing along the lines of extreme fear and imminent danger and things of that nature borders on a violation of Section 29. It has to be not in the conclusionary terms of how you're phrasing it. So you can't make it seem as if you're leading him to that answer. Ms. Emerson says, I could ask in the way that the heiress court is suggesting, which is to ask him how could his experiences and symptomology as a person suffering from PTSD have impacted his perception of danger and imminent harm? And then he will give the answers. Yes, says the court. Ms. Abramson says, that's nice. That fits within the heiress construct. Okay, that was a good way to do it. So how does his symptoms that he's experiencing, how would that affect his state of fear and afraid? So the court allows her to do that. The court says the heiress court didn't think it through, unfortunately, because really all they did was give some general language, as I said, without having been confronted with the specifics of what the testimony is. I said this before when I ruled on the issue. The admissibility of the expert testimony and limitations upon it, according to Section 29 of the Penal Code, then that the heiress court talks about how the evidence is admissible, but also talks about Section 29, and there's really a built-in conflict between the two. It's not easily resolved. Ms. Abramson says, I know. The court says the way you're proposing to do it the way you're proposing to go at it by referencing the belief of the defendant of fear, extreme fear, and imminence and things of that nature is consistent with post-traumatic stress disorders, getting very close to a violation. Ms. Amerson says, well, philosophically, I would tend to agree with you. I have just read the same language in Eris that the court read. Basically, what they're saying, even though it may not make philosophical sense, they're saying you can't do it directly, but you can do it indirectly. You can't do it right at the baseline, but step back, not right at the line of scrimmage, but drop 10 yards and punt. In other words, what they're saying is this, that it is consistent that someone with post-traumatic stress disorder would have an actual belief in imminent harm. That seems to be permissible. The would phraseology, whereas did have phraseology is not. Now, we can agree, Your Honor, as a philosophical matter, for all intents and purposes, that might not make a whole lot of difference to a jury. We could also agree philosophically that the whole controversy, or there was such a thing as diminished actuality, when in fact we know it only makes sense to talk about diminished capacity is another one of those fictitious constructs. Whatever the psychological or logical problems we may have in making these distinctions, the Supreme Court is making the distinction. And I think the reason is there really doesn't seem to be any way to ensure that a jury can be told of the linkage between mental disorder and the specific facts in a case while avoiding Section 29. Then, by employing a fiction, which is, the screenplay, meaning the screen as the football, not as in television. Well, I'm getting to be like Mr. Gessler, using football analogies, but not very good ones. Like a backhanded compliment. I mean, it's not even a compliment. It's just like I'm starting to turn into Mr. Gessler saying football analogies, but they're bad, so they're not even good analogies. So why am I bothering? Kind of. That's funny. I think the point is, yes, the impact logically may be the same on the jury, but we engage in quite a few fictions about what the jury does and doesn't do with information. And I think the real prohibition is they can't hear the expert say he did have this fear, or I am of the opinion that he did, in fact, have this fear. I think so long as we structure it and I introduce it as I intended to do, with acknowledgement that the witness can't know, what's true and what isn't true in any absolute sense, but that if in his opinion, this defendant had PTSD, knowing from his experience how that affects people in these situations of confrontation from someone that they allege has been abusing them. The court says would affect some people in this situation if, as an expert, he can say all people with post traumatic stress disorder. I'd like to hear him say that. Ms. Abramson says, I didn't say he was. The court says, you said affect people. The way it sounds is everybody would react that way. Ms. Abramson says, no, there certainly is a tendency that's a cause of problems for people with post traumatic stress disorder that they overreact to threat situations. So, in that sense, therefore, an overreaction to a threat situation is consistent with PTSD. Now, he would say they don't always. It isn't going to flow automatically, and that I'm sure would be brought out on cross examination because he isn't going to say anything ridiculous. But the fact of the matter is, it is not inconsistent. In fact, it is consistent with post traumatic stress disorder in a child abuse context. That when you're threatened with further abuse, do you fear? Do you read cues? Do you sense danger? Your sense of that danger is imminent. That is consistent with the state of mind, is consistent with post traumatic stress disorder based on abuse at the hands of the person from whom you're receiving a cue. And that's what he can say. Does that mean the jury is going to say he's saying it's consistent, which means that's equally what happened? Well, that's not what the language means, and I'm sure Mr. Khan on cross examination can bring that out. I think basically what the Court of Appeal there is saying is it's just so long as you put that distance between the ultimate opinion and the notion that there is a linkage between battered women or post traumatic stress disorder and the individual's perception of danger and its imminence, then both sides have gotten, the provisions of law that apply. Otherwise, there would be no point in the heiress court saying that the expert should be entitled to testify to how the experience of Mrs. Harris as a battered woman affected her perceptions. How can you say how it affected her perceptions if you're not allowed to talk about those perceptions? Exactly. The court says, again, reference has to be to the perceptions as described by the defendant. Ms. Abramson says, yes. The court says, not by counsel and not in conclusionary fashion, and whether or not those perceptions, as expressed by the defendant, are consistent or inconsistent with a diagnosis of post traumatic stress disorder. But again, I can only reiterate I'll have to wait and hear what the exact questions are, sorry. And I don't see any need to go any further at this point. I'm sure there will be further objections and we'll have further discussions, but I think the parameters are generally on the table here. I'm not in a position, and I don't think it's appropriate in the context of this sort of testimony to prescribe precisely what it is that the wording will be of every question. And I wouldn't do that. with the understanding that the witness who's in court understands that he shall not state any personal opinions, that the defendant believes that he was in danger or fear of imminent danger of death or great bodily injury, or acted because of such beliefs, that is beyond the province of expert testimony. With that, we'll have the jury come out and you can start up again. So basically, he's going to let the jury decide things when it comes to, did Erik have PTSD? You can't say that an expert can't conclude that he did, so you have to talk in general or hypothetical terms. So now we're going to go to direct examination continued of Dr. Wilson. Court says the jury is back. We'll now resume with the testimony of the witness. Ms. Abramson says, "Thank you, Your Honor." Dr. Wilson, in the course of your evaluation of Erik Menendez, did you take information from him concerning the events of the last week or so before his parents were killed? Yes. Did you go over that area with him in some detail? Yes. And did you also read the 10 days of testimony that he gave in the first trial? Yes, I did. Did you read the 15 days of testimony that he gave in this trial? Yes. And did you, in your own mind, strike that? Did you read Mr. Menendez's testimony with the view to seeing if the details that he testified to concerning that last week were consistent with the information he gave you? Yes. And was it consistent with information he gave you? It was. And in reviewing all the materials that you were provided with this case, did you formulate some opinions about Mr. Menendez's status as a person suffering from post-traumatic stress disorder and the things that he reported to you and testified about as being his feelings and his emotions and his mental processes during that last week? Yes. And did you formulate opinions about the relationship between his post-traumatic stress disorder and certain of these emotions and perceptions that he relayed to you having to do with a variety of the issues that we have talked about so far in your testimony? Yes. And did these include issues having to do with the misperceptions that are attendant with people who are in abusive relationships? Things that happen to, misperceptions about, those abusive relationships, he says. Yes. Such as the running away issue and failing to report and feeling isolated, learned helplessness, those things that we talked about. Correct. Did you also form opinions about the connection, if any, between post-traumatic stress disorder and its symptomology and the specific expressions of safe perceptions and feelings and emotions that Mr. Menendez claims were in operation at the actual moments before the shooting? Yes. Now, before we get to going through those opinions of yours concerning the information you received from him, I want to turn your attention to another section of the Diagnostic and Statistical Manual, or what we've been calling the DSM-4. We're currently on the 5, but the 4 was in play back in the 90s, apparently. Is there language in the DSM-4 addressed to a person such as yourself who's making an evaluation of someone in certain settings to use a certain type of cautious approach? Yes. And what is this section? First of all, what is the label that is used to describe an issue that evaluators in a forensic setting should be dealing with? The label is malingering. And is malingering a mental disease or disorder? No. What is malingering? We'll strike that. Why is this word malingering in the Diagnostic and Statistical Manual? The reason the word malingering or labels is as in the Diagnostic and Statistical Manual of the American Psychiatric Association is it refers to the intentional faking of symptoms or the feigning or production of symptoms when in fact they don't exist. So you're making them up to try to pretend to be crazy or whatever. So the importance to the diagnostician or clinician working with the manual is you want to be able to discern whether or not, in evaluating a person for a mental disorder, whether or not they generally have the condition. That is, that it actually conforms to a true psychiatric condition, or discern whether or not they're attempting to exaggerate symptoms when in fact they don't exist. Now, do you have this in the back of your mind, the issue of malingering, every time you do an evaluation of someone, period? Yes. Do you have it in the back of your mind as something to consider even if you're only doing an evaluation for treatment? Yes. Now, what does the manual require? Strike that. Are you directed, however, by the manual to consider the possibility of malingering in certain situations only? I'm not sure what your question is. Does the manual, the DSM-4, direct you to you, the evaluator, you, the clinician, to always rule out malingering even if it's only to treat a patient in therapy? No, not necessarily. Does it identify certain situations where there may be a motivation on the part of a person to fake an illness, a mental illness? Yes, it does. To put it simply, what are the situations that the manual calls the evaluator's attention to where people may want to fake? In the manual, they list 4 areas of consideration for the evaluator to consider in terms of ruling out malingering. Well, before we get to those 4 specifics, what I'm talking about is, do they specifically call the attention of the evaluator to a forensic evaluation for legal purposes? Yes, or medical purposes as well. Well, let's start with legal purposes. Are they limiting it solely to criminal cases, or for any kind of legal proceeding where a mental state may be an issue? It could be in any legal proceeding for that matter, says the witness. Ms. Abramson asks, well, what are the other topics or areas? We'll strike that. Is there an actual reference to malingering in the section of the book that talks about post traumatic stress disorder? Yes, there is. Where does it appear specifically with respect to post traumatic stress disorder? In the diagnostic manual, it appears. Sorry about that. Someone was here. Anyways, I don't know where I left off. Where does it appear specifically with respect to post traumatic stress disorder? In the diagnostic manual, he says, it appears on page 427 under the section entitled Differential Diagnosis. And at the bottom of that section entitled Differential Diagnosis, the last paragraph makes reference to malingering. Would you read what the manual says under the differential diagnosis with respect to malingering? Yes, says the witness. It says for post traumatic stress disorder, malingering should be ruled out in those situations in which financial remuneration, benefit eligibility, and forensic determination is playing a role. So obviously, you have uh, you would receive a benefit from lying in a court proceeding, or whatever, to your court appointed psychiatrist. You would possibly want to lie and fake your uh, symptoms that you don't really have, for trying to fake a mental health disorder or whatever. And that's basically what that's saying. So when you say financial remuneration, what does that mean to you? Receiving financial compensation, like a Vietnam War vet claiming to have PTSD and trying to get veterans benefits? That would be one example, says the witness. Another example would be workers' compensation claims. It could be Social Security benefits. Well, did you, in fact, at one time, were you an expert consultant for the Exxon Corporation? Yes. And did you have to do that with the oil spill from Exxon Valdez? Objection irrelevant, sustained. Were you called upon to make an assessment as to were there a large number of claims against the Exxon Corporation by people claiming to have post traumatic stress disorder because there was oil on the rocks that killed the objection irrelevant, says Mr. Khan. Sustained. Let's focus on this case. Ms. Abramson says, is a civil lawsuit by people seeking money that claim to have an illness one of the provisions in the DSM 4 that you're trying to alert the evaluator to? Correct. Financial remuneration means what you just said. What does benefit eligibility mean? Just what it says. To determine whether or not one's eligible to receive benefits of one type or another, it would be pertaining to work or social security benefits or health related benefits, or other kinds of benefits that might take place in terms of employment or other kinds of situations. Insurance payments for therapy? Yes. Okay, and then of course it talks about forensic, which we know means legal. That's correct. Okay, now when it says it should be ruled out, what does that mean? You want to make sure that it doesn't exist, that you're ruling it out. You're saying, well, it's not there. Malingering isn't part of this diagnosis here. So in other words, you have to make a determination that when you make a diagnosis that you're making it based on information that you at least consider reliable. That's correct. Now, what is the actual definition in the DSM 4R of malingering? The definition? Yes. The actual definition states, says the witness, the essential feature of malingering is the intentional production of false or grossly exaggerated physical or psychological symptoms motivated by external incentives such as avoiding military duty, avoiding work, obtaining financial compensation, evading criminal prosecution, or obtaining drugs. Under some circumstances, malingering may represent adaptive behavior, for example, feigning illness while a captive of the enemy during wartime. And when it and then it goes on to say there's some definition. Malingering should be strongly suspected if any combination of the following is noted. Number one, in a medico-legal context, representation. For example, the person is referred by an attorney to a clinician for examination. Number two, marked discrepancy between the person's claimed stress or disability and the objective findings. Number three, lack of cooperation during the diagnostic evaluation and in complying with the prescribed treatment regimen. Number four, the presence of antisocial personality disorder. Malingering differs from factitious disorder in that the motivation for the symptom production in malingering is an external incentive, whereas in fictitious disorder, external incentives are absent. Ms. Abramson says, well, let me ask, fictitious disorder is someone who really believes that they're sick? Yes. And the notion of malingering is that somebody who knows they're not and is just making up a series of symptoms. Correct. Now, is there a difference between someone making up a series of symptoms, which we know is what malingering is, versus someone simply telling us a big fat lie? Yes. With respect to this case, in your evaluation of Erik Menendez, did you rule out malingering? Yes. Starting with the first caution here about strongly suspected of any combination of the following is noted. Clearly, number one, there's a medical legal context is true. The witness says that is true. Next question. I retained you to evaluate Erik Menendez. That's correct. He didn't just walk into your office one day and say, I don't feel good, help. That's correct. Now, with respect to two, a marked discrepancy between the person's claimed stress or disability and the objective findings. Did you mark any such discrepancy? No. Is there any discrepancy between the claimed stress or disability and the objective findings? No. With respect to number three, lack of cooperation during the diagnostic evaluation, did you find any of that? No. Did you find any lack of forthrightness at all in talking to Erik Menendez? No, I did not. Was there anything that you asked him about that he refused to answer? No. How would you describe the way in which he dealt with your requests for information or the way in which he talked to you? I would describe the way that Mr. Erik Menendez responded to my questions as forthright, candid. At times, he was reflective and thoughtful. There were other times, though, in which he was somewhat reticent, particularly when I first began to interview him about the sexual molestation. It was clear to me that it was difficult for him to talk about it. I did not have the sense that he was uncooperative. I just had the sense that it was very painful and distressing area for him to describe to me. Other than that, he was always cooperative, responsive, and direct in answering my questions. Ms. Abramson asks, now going farther in trying to rule out, well, first of all, malingering is a notion of being presented with symptoms. Correct. Can you give an example of how someone who's malingering might talk to you in a way that this definition anticipates or this definition encompasses? In terms of post traumatic stress disorder? Yes, let's say within post traumatic stress disorder. Sure. An example I used previously was a person will come in to an evaluation, or if I'm court appointed to an evaluation, and when I first examine them, they begin to talk about post traumatic stress immediately. What if they don't do that? Let's say it's not that bad. Can someone still be talking to you in such a way that it would be immediate tip off to malingering without ever mentioning post traumatic stress disorder? Sure. Well, what kind of things would they say? Well, the things they typically say is they want to talk about how awful the trauma was and rattle off a list of symptoms right away and describe this great emotional upheaval. This is really right away in the interview process, and that they're incredibly stressed. They're having nightmares, having flashbacks, seeing all these things, and it's really terrible for them. And they do that often without any provocation or any questioning on my part. They just sort of blurt it out. Yeah, usually you don't do that. Miss Abramson asks, okay, now assuming you're not presented with someone who's doing this sort of thing, spitting out symptoms and telling you how awful they feel, let me just ask, did Erik Menendez do that? No. Did he ever describe anything as a symptom? No. Did he complain about how he was treated? No. Did he tell you how messed up he was by what had happened to him as a child? No. Now, apart from this kind of tip off that someone is malingering, do you go farther in looking for certain things in the way that information is given to you, particularly in a legal case? Sure. In order to satisfy yourself that you're getting reliable data? Yes. What is it you're looking for? Normally, what I look for is discrepancies between objective records and the person's account of what happened to them. In many instances, there are good records available, such as hospital records, military records, injury records, police reports, and so forth. There are a variety of objective records that pertain to the traumatic experience or experiences, and those are often good sources of insight by which I can compare what the objective records say or point to versus what the patient is saying to me. If there's a marked discrepancy or a glaring omission or absence, then it's suggestive of an area where I want to explore further whether or not this person is being forthright or exaggerating or malingering as symptoms. In some cases, there is an objective record of the trauma. Oh, I'm sorry. Next question. I thought he was still talking. Next question. In some cases, there is an objective record of the trauma itself. Yes. Like in wartime, there would be a report of a firefight, let's say, that a vet is claiming to be part of. Yes. Or there would be a report of that day's events of his platoon and there was no firefight. Yes. So if he's claiming terrible trauma from a firefight and there's an objective record that contradicts them, that's right. So you can find maligning or malingering in other ways. Here in the area of child sexual abuse, are there documents often available that documents the trauma itself? Not very often. And do you limit yourself then to rendering a diagnosis only where the trauma itself is observed? No, you can't. Do you believe you would be able to render very many opinions on post traumatic stress disorder in cases of sexual molestation if you had to depend upon third party witnesses to verify the trauma? Objection irrelevant. Sustained, says the court. Ms. Abramson says, now, in the absence of an objective record like the plane crash, the firefight occurred, what do you then look to in order to determine, well, strike that. In order to make a diagnosis of PTSD, you need to know what the trauma is, don't you? Yes. And you can't make it in a vacuum and say that there was some kind of trauma and I don't know what. Yes, you need to know the particular trauma. So, in the absence of an objective record that documents the specific trauma, how do you go about determining what it was? In the absence of having an objective record or having other data that would confirm the existence of the traumatic experience, you have to turn to other sources of data that would shed light and provide information on the nature of the traumatic experience or suggest the nature of that traumatic experience as it would be consistent with the presentation of the symptoms. Only let me ask you this. Is there anything about the consistency with which the patient relays the traumatic information? Yes. Objection irrelevant, no foundation. Sustained, the answer stricken, says the court. Ms. Abramson says, do you place any reliability on, we'll strike that, is the consistency with which the information is reported vital in your being able to come to a diagnosis? Objection irrelevant, motion to exclude under 352. Sustained, says the court. Ms. Abramson says, all right. How do you eliminate, if there's no objective evidence of the specific trauma, how do you eliminate the notion that it's being made up? Objection irrelevant, evidence code 352. The court says, in a general sense, you can answer the question. The witness says, one of the ways that I do that is to look at the consistencies in the report of the patient. Mr. Khan says, I will object at this point under evidence code section 352. Overruled, says the court. You can answer the question. The witness says, one of the ways that I do that is to look at the consistency of the reports of the patient, particularly if they've been seen by more than one treater, more than one provider, one or more diagnostician. So their account shows consistency over time. Generally, when someone is malingering, you find inconsistencies. Related to that, more importantly, is where you might see inconsistencies in the evaluation of the person by more than one evaluator. That is to say, different points in time, the person may have been seen by more than one person making a judgment about their condition. And if the perceptions of the evaluators are consistent in terms of the analysis of the symptom clusters as they relate to the traumatic experience, that's highly suggestive that there's a consistency in the perception of the evaluators as well as the symptoms being reported. The last way that relates, these two are interrelated. One has to do with whether or not reported symptoms by the patient are consistent with what's known in the specific and medical literature about the syndrome. And that's a diagnostic way. Does it conform to what we know about the condition? Let me just finish, please. Related to that is the experience of the clinician, so that, for example, in my experience, if someone is reporting a particular kind of traumatic stress response and it doesn't jive with what I know based on my experience with thousands of trauma patients, then I have to ask myself the question, what's going on here? This doesn't seem to fit. There's something wrong with this picture, and then I need to evaluate what seems to be wrong. Ms. Abramson asks, in this particular case, when you were doing your evaluation of Erik Menendez, were you trying to see if what he described by way of the experiences he lived through and his reaction to them was consistent with PTSD in general, or more specifically with PTSD as a consequence of child sexual abuse? Both. Were there areas of difference in the frequency in which certain symptoms occur between people who are suffering from PTSD because they were in incest situations versus, for example, those who were in plane crashes? I'm not sure I understand your question. Could you rephrase it again for me? You've already established that people can establish post-traumatic stress disorder from a single catastrophic event like a plane crash. Yes, they can. They can also develop it as a result of a war experience. Yes, being tortured or taken hostage. Correct. And they can develop it as a result of being molested as children. Yes. And specifically, incest families where they're molested repeatedly by a relative. That's correct. Do the symptom clusters differ somewhat depending on which form of trauma the person has experienced? Yes. Are there patterns which are the most common symptoms of trauma for people who were molested as children that are somewhat different than the symptom clusters for people who were in an accidental type traumatic incident? Yes. So different patterns for different types of trauma. And so when you screen someone to see if they have post traumatic stress disorder as a result, say, of incest, mhm, and are you looking for a certain relationship between the symptom clusters that are most, let me read that again. Are you looking for a certain relationship between the symptom clusters there that are more specific for incest, for example, than plane crashes? Sure. Do you make do you make those comparisons in this case? I did. Now, the DSM talks about the exaggeration of symptoms as being an aspect of malingering. In your opinion, when Erik Menendez was talking to you about what happened to him and how he felt afterwards, did he seem to, exaggerate a little around the edges? On the contrary, I felt that he tended to minimize the psychological consequences of his sexual molestation by his father and the other traumatic, stressful events that occurred in his life. He had a general tendency to sort of gloss over it rather than to exaggerate or to go into detail or depth without talking about what actually happened to him. That's very common. It's not I mean, it's hard to talk about these things. You don't want to talk about the really, really tough stuff. So you might just glaze over it so that you kind of give a little bit, but not a lot? Was that tendency, particularly to minimize, marked with respect to the treatment he received by his father? Yes. Now, if you can't find documentary evidence or witness evidence to corroborate the specific trauma, do you look for such evidence to corroborate the environment in which the trauma occurred? Yes. Was there corroborating evidence from your perspective sufficient to allow you to make the diagnosis in this case? Yes. Objection irrelevant, sustained. The answer stricken. That's bogus. Ms. Amerson says, do you attempt to find in third sources corroboration of the existence and appearance over time of symptoms of post-traumatic stress disorder? Objection irrelevant. Overruled. Yes. Did you find, in looking at all the materials that you examined in this case, evidence of the appearance of symptoms over a long period of time? Yes. Were there symptoms apparent to third parties before Mr. and Mrs. Menendez were killed? Yes. Now, it also tells you in the DSM 4 when you're dealing with ruling out malingering that you have to be concerned with the presence of antisocial personality disorder. That's correct. What is antisocial personality disorder? That refers to a personality disorder characterized by disposition towards dishonesty, ruthlessness, cunning, antisocial acts such as vandalism, theft, injury to animals, a wide range of symptoms pertaining to both conduct and orientation towards people, which includes, in addition to what I've just listed, a tendency to con people, to use people, to exploit people, to be dishonest in dealings, to be very manipulative. It's the proverbial con artist, if you will, is one component of antisocial personality disorder. It also refers to disregard for rules and regulations and authority and a tendency and willingness to be repetitive, to violate rules and regulations, laws, authority by transgressing over and over again the rights of other people. Antisocial personality disorder, as a personality disorder, is a constellation of dispositions and behaviors that fundamentally are antisocial in terms of acts, attitudes, and interpersonal relationships. Now, does that mean that any person who has stolen something or lied to somebody over the course of their life is an antisocial personality disordered person? No. Is stealing a relatively, I mean, like it or not, a relatively common concern among people? Objection. Argumentative as phrase. Sustained. Would antisocial personality disorder apply to people who, for example, chronically cheat on their income tax? It could apply to them, sure. Could it apply to people who routinely lie to their wives about extramarital affairs? Yes. But do those acts, if that's all there is, mean the person is antisocial? Not in and of themselves, no. And did you, as the book requires, rule out antisocial personality disorder for Erik Menendez? Yes, I did. Now, in order to make a diagnosis of antisocial personality disorder, are there a number of criteria that have to be met? That's correct. Did you say one of them involves finding something known as conduct disorder as a child or teenager? That's correct. And did you find, we'll strike that, did you rule out conduct disorder for Erik Menendez as well? Yes. Now, let me just ask you a layman's question. Do people who have antisocial personality disorder, are those the kind of people who are described as not having a conscience? That's correct. Are those people who don't feel guilty or remorse or empathy or compassion for other people? Correct. Are those people who are unbothered by acts that they have done that cause harm to other people? Correct. Are those people often characterized as cruel and ruthless? The court says, let's get beyond this. You've already had him say that he's ruled out antisocial personality as to your client, so the rest of the stuff is irrelevant. Okay, thank you, says Ms. Abramson. What else do you do, if anything, Dr. Wilson, to assure yourself you're not dealing with a situation involving malingering? I think we've covered most of the bases for determining whether someone is malingering, looking at consistencies, looking at discrepancies, where they exist, looking at whether or not there's an intentional feigning or production of the symptoms, and looking to see whether or not the presentation is consistent with the known course of illness or not. When you're dealing with trying to evaluate someone who's recounting a history of sexual abuse in childhood, do you pay any particular attention to the language that that person uses to describe the events? Objection, irrelevant. Overruled, says the court. You can answer the question. The witness says, yes, it's often very important. Well, how important is it? It's important because when someone actually has a history of childhood sexual abuse or incest, that they usually have particulars. They have specific memories of various types that are very specific to their experiences. What I'm referring to specifically are such things as memories of smell, a certain kind of physical recognition. It could be a detail about the situation, the context in which the abuse occurred. It could be an idiosyncratic, a very special personal reference to some aspect of that context of that situation so those kinds of particulars. Those kinds of specifics that are part of the trauma story of this childhood sexual abuse victim are often very valid indicators about the uniqueness of their experiences, whereas someone who's malingering would tend to not have those particulars available to them, like the smells, the sights, the sounds, like I remember being, on the in the closet on the floor, and there was a stain that reminded me of Abraham Lincoln or whatever. Those are triggers. Those are the things that can trigger your PTSD later on. Those senses of yours can later be reminded of a sense that you had when you were in those traumatic experiences. Okay, if someone said that they associate a particular smell with the sexual abuse act, or they associate a particular lighting condition, for example, those are details that make the act seem real. Yes, very much so. Versus generalizations about, like, my father r'd me and my father made me do oral sex. That's correct, says the witness. So in general, is the giving of specific details an indicator to you? Yes. Of reliability? It's also a very good indicator. But I'd also want to add one thing. These may not even be conscious indicators for the patient. Sometimes they can report a detail and not know the significance of it, only later to make the connection between that specific recollection and how it related to something that happened to them that they've forgotten about or repressed or didn't have a memory of during the course of treatment. That's really common. So it could be a detail that doesn't seem to even be not necessarily an elaboration on a sex act, but a detail about the surrounding environment that can have significance. It can be that or the other. It can be a specific act. For example, I'm thinking as you asked the question about a patient I treated who was incested by a stepfather, and she had an odd association to cologne, Old Spice, aftershave, which she didn't understand for years. And in one of her distressing episodes on a date, a boyfriend tried to kiss her and he had Old Spice and she threw up. She was very embarrassed about it. She didn't understand, why did I do this? She wasn't ill or intoxicated or anything. It was only later that she was able to make the connection that this boyfriend attempted to kiss her and she smelled the Old Spice and it triggered this recollection. So she didn't even realize the Old Spice was what was being worn by the stepfather. She knew it was. She didn't make the connection to the boyfriend when she threw up on the date. Well, apart from giving an account that has details, is there also something about the use of descriptive language? Well, let me just ask it more directly. If a person claims to have been molested as a child, would you be suspicious if that person, in telling you about it, uses very sophisticated adult language? Yes. For example, in talking about fellatio or cunnilingus or those kinds of technical words for sex, would be suspicious? Yes. What kind of things did you listen for in order to help you validate the information that you're hearing? Objection, irrelevant. Ms. Abramson says, in that sense, irrelevant, says Mr. Khan. The court says, I think it's really cumulative at this point. He's already described it. Let's go on to something else. Let me just ask one fact-specific thing. Did you attach any significance to the fact that Erik Menendez told you that he had his own idiosyncratic name for different kinds of sexual interactions between himself and his father? Objection, irrelevant. Sustained. Everything gets sustained. I'd like to be heard on that. The court says, okay, let's move on to something else. Ms. Abramson says, now, are you aware from the testimony in this case and the testimony and notes of Dr. Vickery from the first trial of the way in which, or of the timeline at least, in which Erik Menendez's revelation of sexual molestation as a child came about? Yes. And does it have any significance to you, the way in which it was revealed and to whom? Objection, irrelevant. All right, we'll hold a hearing on these objections and we'll do it in the hallway right now. Thank you, Your Honor, says Ms. Abramson. The following proceedings were held outside the presence of the jury. Apparently, we're in the hallway, but we're just going to call it a sidebar in our timestamps, which are below this video in the description. We're back. Well, sidebar. The court says, okay, so Mr. Khan, the court allows Mr. Khan to speak. He says, yes, here we're getting into the unproven criteria. Counsel is suggesting there are certain means by which an expert can evaluate whether or not the person has truly been molested or not. We took detailed testimony concerning this area from all the witnesses in a hearing conducted in this court some time ago, and the result of that hearing was that there are no factors by which experts can evaluate whether or not a person has been molested based upon these unproven, untested criteria. And that's the reason why the California Supreme Court in Bledsoe and Bowker has said that child sexual abuse accommodation is inadmissible. Whether or not people call it child sexual abuse accommodation syndrome, this is precisely what we're getting into now. Consistency of reporting and the tone of voice or the particular language that's used. And everyone has their own criteria, and some rely upon different criteria. It's all unscientific and unproven, and we're now presenting it in such a way that it makes it appear as if it's a valid basis to determine whether or not someone has been molested. He has already described in broad features how he makes a determination. He said he does it by means of the self-report, and then he looks to other factors and he lists those factors, including reports from others. And I think he even referred to what counsel is now getting into as in a broad category. But now to take detailed testimony concerning it, I think should be excluded under Evidence Code 352. Ms. Abramson says, I don't know how we got from this to Bowker. I think what I'm focusing on is Ainsworth, and this witness is right to show that he is not being irresponsible and he's not being, that his conclusions and his diagnosis is based on a careful process by which he weighs things of significance. And I think there's only two areas here that I was trying to get to. One has to do with the fact that Erik Menendez was using age appropriate language and terminology to describe it, which is something he looks for, as well as having specific details, which I didn't ask since the other was objected to, but I'd like to ask. And the other is on the malingering scale, the fact that it's his understanding that the client did not immediately tell one and all, oh, gee, he was molested, and start talking about it, but that it appeared to take a significant period of time and very gradual revelation before he would talk about it. And we already know, and I don't even have to ask the question, that there is a reluctance on the part of incest victims to talk about testimony. And so I think it's important to validate his diagnosis that he is being careful and he is looking to these kinds of signs before he would basically come up with such a diagnosis with such a traumatic causation, which he clearly has to find and did find. Moreover, I mean, my client's credibility was attacked by Mr. Khan every breath he took, everything he said he was accused of lying, and the molestation, you are making it up. The court says, wait, quiet down. Ms. Abramson says that it didn't happen. You've made it up. The reason, because it's not true. The court says that's the defect in your examination of this witness. You're going beyond establishing credibility of his opinions, and you're now trying to buttress the credibility of your client, which is not what this witness is testifying for. Ms. Abramson says, well, if the attack on the credibility of my client is based on misperceptions that Mr. Khan shares with the uninformed of this world, the court says, let's stop these remarks. They just don't help at all. That's the type of remark that just doesn't contribute to the merits of whatever argument you have been by making snide remarks about opposing counsel. I wasn't trying to be snide, says Ms. Abramson. You are doing that. You were snide, and there's no reason for it. Just stop doing it. Ms. Amerson says the whole attack was on whether he didn't talk about it or run away, whether you didn't tell anybody before you were arrested, sort of perpetrating the myth that the way my client acted was contrary to the way molested child would act. Now, I think I do have a right to have expert opinion point out that those behaviors are not contrary but are consistent with the way a molested child would behave. And by the same token, I believe I would have a right to say that the way in which he discussed it is consistent with the way molested children in known cases discuss it. That's all this is. That's all this is for, since the attack has been made that he is somehow idiosyncratic, my client, when we know the converse is true. The court says, well, when this subject came up originally, the court rules that you can dispel certain misperceptions, separate and segment in the witness's testimony some testimony about general misperceptions or misconceptions. And he could describe those without going into the specific facts of the case. You're doing just the opposite of that, and you're combining the two with just the opposite approach of syndrome evidence and his conformity with certain syndrome evidence, not post traumatic syndrome, but just the syndrome of a child's sexual abuse accommodation, so that the jury would conclude that your client, because of the facts of the case, fit those criteria, therefore, he must have been sexually abused. It compounds the issue that is always of concern that the jury will take this witness's testimony that your client suffers from post traumatic stress disorder, his testimony as to the causation for the truth of the fact that your client was, in fact, sexually molested. That is not the purpose of this witness's testimony. The purpose of this witness's testimony is to deal with the mental state of the defendant at relevant times, and we have yet really to get into that, although we did take a good deal of time this morning and this afternoon to discuss it. I think you've covered the area completely and fully at this point. You've gone from malingering, a description of malingering, and all sorts of material that he has considered, and the validation of his opinion, and I think you've covered the area quite frankly. Is it really up to him to decide that this is how she should use this witness? I mean, shouldn't she get a say as to how this witness comes in and what his testimony is? Like, I don't understand why it's only limited for these purposes and blah, blah, blah. I mean, that's probably maybe an earlier ruling is from the court, like in pretrial stuff that we don't have, but I don't know. Miss Abramson says there's only two other things. If I can just ask in a leading manner, then we can get out of here. That with respect to the Ainsworth, for example, appropriate, the court says he's described the way your client talked to him and gave him responses. It sounds like it came right out of Ainsworth. So Miss Abramson says he was listening while you quoted the case. Judge, I would also just like to bring out the fact that he is aware of the way in which it is revealed in stages to various people. The court says, first of all, it would all involve hearsay as to the details of what it was. Ms. Abramson says, I wasn't going to ask for details of what he said to him. The court says he's described it. I think he's already testified about this in earlier reference to Dr. Vickery. This has all been covered and it's going on ad nauseum. At some point, you've got to get to the issues here. Wow. Ms. Abramson says you want to do it now or take the break. The court says, let's start. Ms. Abramson says, okay, the following proceedings were resumed in the presence of the jury. All right. The court says, next question, please. Ms. Abramson says, Dr. Wilson, you see on the blackboard there an exhibit that I believe we've marked now 403. Is that correct, Your Honor? The court says, I believe so. Ms. Abramson says, or 402. I marked it on the back. Of course, I can't see it. The court says 403. Okay, 403, says Ms. Abramson, and this is, Dr. Wilson, a sort of thumbnail sketch or summary of events as testified to by Erik Menendez in this trial that occurred between Sunday, August 13th, 1989 and Sunday, August 20th, 1989. Is okay? Okay, so that's that whole week. The 20th is the day of the homicides. So, as we know, that week was tense because Erik had Lyle talk to Jose. It was lots of tension in the home. Now, just if we can, have you received information from Erik Menendez directly and from reading his testimony concerning the fact that he had been in Kalamazoo, Michigan with his parents playing in a tennis tournament in early August, right? That's correct. You also received information, did you not, that after losing that tournament, there was conflict between him and his father? That's correct. Did you receive information from him concerning an act of sexual conduct demanded by his father after he returned home to Los Angeles from the Kalamazoo tournament? Yes. Did that act of sexual conduct figure in your assessment that at the time of the shootings, a week later, Erik Menendez was still living in a trauma-inducing environment? Correct. And that he was someone who was suffering from acute stress disorder, acute traumatic stress disorder, as well as post-traumatic stress disorder? Correct. Now, I'm going to ask you basically to assume certain things hypothetically, okay? You were given the information and are aware of Mr. Menendez's testimony that on approximately Saturday, August 12th, before we get to this chart, he had had a discussion with his father about his future, about what courses he's going to take and what career he's going to have and where he's going to be living and that sort of thing. Yes, that's correct. And assuming just for the sake of the question that discussion actually happened based on your assessment of Erik Menendez as a person suffering from post-traumatic stress disorder, was there anything about that particular conversation that would have caused any stress reaction or particular reaction on his behalf? Well, yes. The conversation had to do with whether or not he would be playing tennis if he attended the University of California at Los Angeles. Did Erik Menendez indicate to you that he had mixed feelings about that issue? Yes. And therefore, as a result of this discussion that we are assuming occurred, did this increase stress or decrease stress or have no impact on it? Mr. Khan says, I would object, irrelevant and improper expert opinion. Sustained to the form of the question. Ms. Abramson says, okay. Did this conversation then have any significance with respect to the symptomology or with respect to his condition as someone with PTSD? Objection irrelevant and no foundation. The court says sustained as to the form of the question. Ms. Abramson says, Your Honor, can we take the recess now so I can figure out how to do this in a way that will be most expeditious? The court says, okay, we'll take a recess and resume in 25 minutes after the hour. Don't discuss the matter with anyone. Don't form any final opinions. We'll resume after 25 minutes. We will ask that counsel remain. Ms. Abramson, so now this is outside the presence of the jury. Ms. Abramson says, that's what happens when you don't get the answer you expect, Your Honor. That's the problem. I'm sorry? Ms. Abramson says, I didn't get the answer I was expecting on that one because I didn't frame the question artfully enough for the witness. The court says you didn't frame it artfully enough to override an objection. So what was it you're trying to ask? Ms. Abramson says, because this did not, in my understanding, this conversation did not contribute to the increase in PTSD symptomology, and that was the answer I expected. And the witness didn't understand the question, and then I wouldn't have had to ask the follow-up question. That's the problem. The court says, well, again, his analysis of the fact situation isn't the issue here. It's what the defendant testified was his reaction to the events. Exactly, says Ms. Abramson. The court says his thoughts and mental state and whether or not that is consistent or inconsistent. So fact situations by themselves have no relevance. It's just ultimately whatever the defendant has testified and how that plays out in regards to this diagnosis. Ms. Abramson says, I understand that, Your Honor. My recollection was my client testified that he was not particularly upset by the conversation and it did not lead to any sense of fear or dread on his part. And that's what I expected the answer to be along those lines and move on. But I didn't get the answer I was expecting, so we sort of hit the brakes. The court says the question was asking him to ask the witness to assess the reaction rather than citing what it was the defendant said was his response. Ms. Abramson says, but I asked him to take into account what the defendant said about this, so maybe I was too subtle. The court says again, I believe you're going to have to, and it might require you to refer to transcripts to describe what it was that was said by the defendant rather than use conclusionary phrases and statements that might or might not be a reflection of what he actually said during his testimony. So that's really how I look at it. You're going to have to get to the specifics of what he said and not how you conclude or how you analyze what he said, but what he actually said. Ms. Abramson says, well, I was trying to actually avoid having to repeat word for word what my client said since the jury heard it. The court says, but by stating things in a conclusionary fashion, oftentimes counsel has the opportunity to editorialize, and in the end, what you say becomes what the witness said rather than what the witness said. What? What you say becomes what the witness said rather than what the witness actually said. And really, the reference should be to the witness's testimony, not yours. So keep that in mind. Ms. Abramson says, we're going to have a problem with that, Your Honor, because I don't have all the testimony word for word in front of me, and maybe the witness has memorized it, but I certainly haven't. Court says, well, the reference, as I said, has to be to the defendant's description of his mental state and not yours or the witness's. Miss Abramson says, some of that I don't think is a problem. Can I at least slightly paraphrase? The court says, I can't rule on it until I hear what you say. I don't want to get into ruling on every question before it's asked. Miss Abramson says, my client is volunteering to do this portion of the examination since he remembers it. The court says, we will be in recess until 25 after. So they take their afternoon recess and come back. Mr. Khan says, we have something outside the presence. The court says, yes. So we're still outside the presence of the jury. And Mr. Khan says, Your Honor, at this time we would object. We had an opportunity during the recess to take a look at the chart that counsel has put up on the board for the jury, and we would object to the use of the chart at this time. And specifically, we have 32 objections to the use of the chart. 32, says the court, 32, which we noted. So we made good use of the recess. What a bunch of dickheads. She already showed it to them earlier, and all was fine and good and everything, and the court even said, yes, I think he can refer to these things on this chart. Now all of a sudden, we have 32 objections from the state on this chart because it talks about the events leading up to that week, leading up to the murders. And anything that has to do with trauma, they don't want. And there's very traumatic events that took place that week, and that's what it's highlighting. So, anyways, the court says 32 entries on that chart. We made good use of the recess. The first thing we would object to is throughout the chart, it refers to both defendants on a first name basis. Erik and Lyle is referred to, and it is our position that if questions cannot be asked of the witness concerning the defendants on a first name basis, then I don't think it's appropriate to have a chart which refers to each defendant on a first name basis. Then we went through the chart to find what we believe to be misstatements of the evidence in the trial, and that's where we came up with the remainder of our objections. On Sunday, the chart, that is August the 13th, the chart reveals that the father informs Erik that he will not live at the dorms all the time. He must come home and sleep at the house 3 times a week. It is my recollection in this case that there's no reference to a specific number of times that he would have to come home. I think there was, but he would have to come home a couple or several times a week. There is a reference, maybe it's a couple or several, I don't remember, but I thought there might have been like 2 or 3 times a week he had to come home still. There is a reference to the fact still on Sunday that the purpose for him coming home several times a week was so that schoolwork could be monitored. That was not the choice of language chosen by the defendant, and we will object throughout the chart to the use of the language which appears to be an argument of counsel rather than any specific recounting of the language used by the defendant. I believe he testified that he was going to have to come back home periodically so that they could discuss the schoolwork and what was going on in school. On Tuesday, we have Erik Menendez observing the dispute between his brother and his mother, and it says that his mother tore off the hairpiece and threw it in the face of Lyle Menendez. There's no testimony in this proceeding that it was thrown in at the face of Lyle Menendez, only that it was thrown at him. It says that Erik Menendez is stunned by his mother's violence. I think that is an argumentative that as to whether or not he was stunned. He testified to his reaction to the incident, but he did not use that choice of words. It says that he feels empathy for Lyle. Once again, this is conclusion by counsel rather than his testimony in this proceeding. It says at this point that he consoled. Ms. Abramson says, "You know what I think might be useful? Why don't we take the chart down so you're not standing right outside the jury room?" Mr. Khan says, "That's all right. I can do it from here." Ms. Abramson says, "All right." Mr. Khan says he followed Lyle Menendez for the purpose of consoling him. Again, that's not his choice of words in this trial. I think that is argument as to whether or not that was his purpose. It also says that he went to commiserate with Lyle Menendez. Once again, that was not the choice of words, his choice of words. It says that this occurred when he went to commiserate with him in the face of the recent increased parental hostility towards both brothers. That is purely argumentative that there was recent increased parental hostility towards both brothers. Counsel can argue that if she chooses at the conclusion of the case, but that is not the evidence before the jury at this time. We would argue that what was going on does not reflect parental hostility, at least between Jose Menendez and his son, Erik Menendez, at this point. For Tuesday, it also has the entry that Erik doesn't tell Lyle that their father threatened to kill Erik if Erik tells Lyle about the sexual abuse. There was no specific threat by Jose Menendez that he would kill Erik if Erik tells Lyle about the sexual abuse. Yes, there is. He told Jose, Jose always had told Erik, "If you tell anybody, I will kill you." Yes, that was a threat. So this dude's just outright lying. The threat was that he would kill Erik if Erik told anybody. And I believe there was also reference to Jose Menendez about killing the person who was told. Court says, "All right, let's stop for a second and ask the defense, what is the purpose or what is it that you're going to do with this chart?" Ms. Abramson says, "Just help Dr. Wilson follow along by remembering specific facts that he was told." This chart reflects, number one, I disagree with Mr. Khan so far as it mischaracterizes facts, but beyond that, it reflects what was told to Dr. Wilson, and even if there were, which I don't concede there is, some slight deviation between what's on the chart and what Mr. Menendez testified to, Dr. Wilson is permitted to testify to what Erik Menendez told him. The court says what Erik Menendez told him is not received for the truth of anything. If there is an instruction, if the people request such an instruction, it will be given. Ms. Abramson says, "My point is this, that this is a synopsis of the crucial events. The reason they're up there is to guide Dr. Wilson through the events so that he has a recollection of what happened. With respect to the specific words that Erik Menendez used, those will be contained in the question, not necessarily based on what's on the chart, although I think the chart is 98% probably word for word or summarizes accurately what Erik Menendez testified to. It doesn't purport to be a verbatim transcript because we couldn't do a chart that's a verbatim transcript. It's supposed to summarize events as Erik Menendez testified to them with the meaning that his testimony gave the events, whether it's the specific word or not. So that's what it's for, to guide the witness through. I would also point out that the chart has been sitting in this courtroom since the day of opening statement, and I mean, it's been there all along, and the people could have looked at it any time. But in any event, I think that the people are simply nitpicking at this point. The specific choice of words to describe in summary fashion what happens is not what Dr. Wilson is basing his opinion about consistency or inconsistency with PTSD symptomology on. I mean, I think that's the point. I'm not going to ask him to be reading things from the chart, but the chart is there to let him recall when the events that he was told about and the events he read about in the testimony actually occurred and what the nature of those events were. The court says, okay, if that's the purpose of having the chart, then there's certainly no reason for it to be up there on the board for the jury to see it if it's just to assist the witness. What? Why wouldn't the jury need to see it? Well, he can't see it. Where else can I put it? The Court says, I don't know. I guess you can make a smaller one for him, but I don't see any reason for the chart to be up there. Are you kidding me? It's been there this whole time. Ms. Abramson says, Judge, it also helps the jury follow along with what was testified to. These are accurate summaries of what the testimony was. The court says, but the witness is not going to be testifying to events. He is going to be testifying as to what the questions asked and answer given of certain responses from Erik Menendez regarding his mental state. Ms. Abramson says first, he has to acknowledge he is aware of the recitation of the event and then the reaction to the event. State is being so nitpicky. This is so ridiculous. The court is being ridiculous about this too. The court says this chart being in such a fashion where it's possible for half the jury to even read it. It's impossible for half the jury to even read it because it's such small print. Doesn't help anybody, so I'm going to order it removed. Ms. Abramson says, Judge, if the jury can't read it, then why can't the witness refer to it? I'm ordering it taken down. Mr. Levin says, only on the 11th objection, Your Honor. The court says, what was that the 11th? Yes, says Mr. Levin. Ms. Abramson says, that's what Mr. Levin is here for, to keep count. The court says, all right, let's get the jury out. The jury enters the courtroom and the following proceedings were held. So he's taking the chart down, even though there's no real reason to. And it was on the 11th objection. We're okay. We continue on. The court says, okay, let's resume, please. Ms. Abramson says, thank you, Your Honor. Dr. Wilson, you understand I am going to be asking you a series of questions about events of the last week to ask you some hypothetical questions, the ultimate hypothetical questions about the information. Okay. Okay, so let's start out. Let's go back to Saturday the 12th, and let me ask you first this preliminary question. Do you have in mind Erik Menendez's testimony in this trial that on approximately Saturday the 12th, his father told him what classes he would be taking in college, what courses of studies he would be following, the fact that he would be going into business with his father in the future and they would be living in a compound in Florida, as well as telling him this is the father telling Erik Menendez that it was not decided yet if Erik Menendez would be playing tennis for UCLA or not? Yes. You reviewed that testimony? Yes. All right. You also recall the testimony from Erik Menendez that his reaction to that information was number one, he was not surprised nor particularly upset that his father was choosing his future for him. Correct. And do you further recall his testimony that with respect to whether he would be playing tennis or not, that he was uncertain about his future, that on the one hand, while he enjoyed tennis, on the other, it was something of a relief to know that the lifelong pressure of tennis performance may be ending? That's correct. All right. Now, assuming for the purpose of the question I am about to ask you that those events actually took place as Erik Menendez testified to, okay? My question is the reaction that Erik Menendez testified to of passively accepting his father's decisions consistent or inconsistent with the symptoms of PTSD that you've described having to do with dependency and helplessness? Yes. Well, is it consistent or inconsistent? It is consistent with it, yes. Is that passivity that conversation illustrates consistent with your assessment that in a report to you of what was done in his life by his parents, Erik Menendez was underreporting or underemphasizing the impact because he had a passive and accepting nature? Yes. Now, moving on to Sunday the 13th, have you in mind testimony by Erik Menendez in this proceeding that on Sunday the 13th he had a further conversation with his father wherein his father told him that although he would be registered as living in the dormitories at UCLA, he would be required to come home several or a few nights a week so that the parents could be involved in his schoolwork and homework in progress? Yes. Now, are you aware or have you in mind the testimony in this case that Erik Menendez's reaction to that was extreme upset, feeling empty, feeling lost, feeling that his life had ended, feeling that he had no way out, feeling desolate, feeling extremely desperate, and that he wound up lying in bed, curled up and crying for some hours? Objection misstates the testimony, argumentative and leading as phrased. All right, with the understanding that this is just counsel's reference to the actual testimony in the trial, and with the understanding that the jury saw that testimony and heard it, and counsel is only giving a summary of what it and her interpretation of it, it's for the jury to interpret the testimony. Just for the purpose of this question, assuming that was the general nature of the testimony presented, that's the nature of the question, assuming that that was the nature of the testimony presented. Counsel may now ask the question. Now, Dr. Wilson, did you read the testimony correct? Yes. If I misstate anything and you know I am doing it, would you correct me? Yes. All right. Is the gist of what I've said what you recall Erik Menendez testifying to with respect to that conversation with his father and its impact on him? Yes. Now, assume for the purpose of the following questions that recitation of facts is in fact true. That is what happened between Erik Menendez and his father that day, okay? Mhm. All right. Now, had you made, well, strike that, in your opinion, in assessing Erik Menendez's situation as he claimed to be a victim of incest, did you determine that he had focused on going away to college as he testified as a form of rescue from the molestation? Yes. In your opinion, did that qualify as a rescue fantasy such as you have discussed and described here? Yes. And in your opinion, if this conversation did indeed occur, would that would that mean that the rescue fantasy was snatched away? Yes. And what would strike that? And is the emotional reaction that Erik Menendez described in this courtroom to having that rescue fantasy ended consistent with how someone in his situation, which we are assuming for the moment to be true, would is that consistent with how they would respond to the destruction of a rescue fantasy? It would be. And would this feeling of being at a loss to know what to do and feeling hopeless and wanting to take your own life, would that be consistent with someone whose coping mechanism of devising a rescue strategy has been eliminated? Is that how those folks would feel? Yes. Now, would the destruction of a rescue fantasy also lead to an increased sense of anxiety and fear? Yes. Is the notion that future sexual assault that a person believed was going to end, the notion that it was going to continue, maintain a high level of anxiety in that person? Yes. Do people who are in the middle of these kinds of situations where they're subject to periodic sexual assault ruminate on the likelihood of sexual assaults occurring? Very much so. Is that one of the things about which they are extremely hypervigilant? Correct. Trying to figure out when it's going to happen next? That's right. And is that especially true when there is no pattern, no specific pattern? There is no way of knowing in advance when it's going to happen. That's correct. Now, have you in mind the testimony from Erik Menendez concerning that Sunday, the 13th of August, 1989, that he eventually came up with the notion of just leaving the house for a few days and packed his bags and then was confronted by his mother, who was angry, who took his clothing out of the bag, who told him he wasn't going anywhere? And then being confronted by his father, who pushed him up against the window, asked him if he was having a problem, told him he wasn't going to leave the house, and told him he was going to deal with Erik Menendez when he, the father, returned from a business trip? Yes. Do you remember that testimony? Yes, I do. And do you remember Erik Menendez indicating that at that point he had no idea of what he was going to do, could think of no options, and was just despairing, basically, and wanting to take his own life? Yes. Is that total lack of being able to think through to other ways to deal with the situation, in your opinion, assuming this is true, consistent with the learned helplessness component of post-traumatic stress disorder that you have determined he was suffering from, the dependency the passivity, and the being overwhelmed with anxiety so one can't really think very clearly. It is. Now, do you have in mind Eric Menendez's testimony in this proceeding that he has no memory of what he did on Monday, the day after these confrontations with his father and mother? Correct. And is the fact that right after, we'll strike that. In your opinion, Dr. Wilson, is this kind of confrontation where a long held rescue fantasy is destroyed a psychologically traumatic event? Yes. In turning to the fact that he has no memory of Monday, would that be, assuming that that's true, would that be consistent with someone who was in a state of being overwhelmed emotionally, who was totally preoccupied and focused on anxiety? Did those conditions interfere with memory? Yes. Does stress keep people from being able to remember the events that occur on extremely stressful days? Yes. And are people with PTSD found to have significant memory gaps? Yes. And in this particular case, did you find that, for example, with respect to his 15th year, are you mindful that Eric Menendez testified he has very little memory of that year? That's correct. Is that what he also told you? Yes, he did. And was it your understanding that that was a time, his 15th year, when he was involved in what he calls the rough sex, the pain and torture aspects of the sexual relationship with his father? Yes. Is there a correlation, in your opinion, between extreme trauma, such as torture situations, and a failure to have memory? Yes. Now, do you have in mind Eric Menendez's testimony that on the Tuesday of that week, the 15th of August? See, these are great questions. The way she's wording them hypothetically, she's knocking it out of the park, in my opinion. I love Miss Abramson. If you can't tell, I fangirl over her. She's pretty awesome at her job here. So now, do you have in mind Eric Menendez's testimony that on the Tuesday of that week, the 15th of August, 1989, he observes a conflict and confrontation between his mother and his brother, Lyle Menendez, in the foyer area of that house? That's correct. Do you have in mind his testimony that he sees actual violence on the part of the mother where she tears off Lyle Menendez's hairpiece? Yes. And throws it at Lyle? Yes. And Lyle is tearful? Correct. And are you mindful of Eric Menendez's testimony that he was stunned by what he saw and felt very badly for his brother and decided to go to his brother's living quarters in the guest house in order to be supportive or to commiserate with him? That's correct. And are you also mindful of Eric Menendez's testimony that while in the guest house, he decides in a highly emotional state to tell Lyle Menendez what's been going on with his father and how his rescue fantasy has been destroyed? Yes. Now, in your opinion, assuming again that those facts that Eric Menendez testified to, and I take it he told you the same things when you interviewed him? He did. So, just assuming that those things are true, did you form any opinion about what the significance was of assuming it happened, of Eric Menendez seeking help now out of the situation by going to Lyle? Yes. What was your opinion about what that signified? It signified several things. Signified several things. First, that he felt a bond with his brother. I will object as calling for improper expert opinion. Sustained. The answer stricken. Okay. Ms. Abramson says, did you form the opinion that this was sort of a fallback or secondary rescue fantasy? Yes, I did. So Lyle is his second rescue fantasy, his second hope for getting out of the situation. Did you note Eric Menendez's testimony that after he talked to his brother, and we will get into some of the details of that talk in a minute or two, but after he talked to his brother and his brother assured him that he, Lyle Menendez, would be able to deal with their father, would be able to convince their father to allow Eric to either leave and go to Princeton with Lyle or to allow Eric to live with Lyle in California, that some of the despair that Eric Menendez had been feeling diminished? Objection, improper expert opinion. What are you asking, says the court. Ms. Abramson says, well, first I'm asking him if he's aware of that testimony. Court says, all right. Are you asking him to assume, first of all, that asking him if he read that testimony and then asking him to assume that that's true? That's what was going to be my next question. Okay, says the court. All right, says Miss Abramson. Are you aware of that testimony? And would you, for the sake of the next question, assume that it's true? Yes. Would the fact that now you have offered the opinion that you thought going to Lyle Menendez after talking to him was a second rescue fantasy? In your opinion, if someone had formulated a second rescue fantasy, would they then experience a lessening of despair or wanting to take your own life? Objection calls for speculation, improper expert opinion. Sustained. Abramson says, is the point of a rescue fantasy a coping mechanism to keep someone from despairing? Objection asked and answered. I think it's already been covered, says the court. Ms. Abramson says, well, I'm just trying to. The court says it's been covered. Ms. Abramson says, did Erik Menendez indicate that he felt somewhat better after talking to his brother, although still very anxious about what might happen in a conversation between his brother and his father? Is that consistent, in your opinion, with someone who has a history of PTSD from sexual molestation who is seizing upon ways out as coping mechanisms? Yes, it is. Now, are you aware of Erik Menendez's testimony that although he felt better after Lyle Menendez pledged to help him talking to his father, that he nevertheless was enormously, we'll strike that he nevertheless was fearful after the conversation with Lyle Menendez because he had told? Yes. And are you aware of Erik Menendez's testimony that over the course of the rest of the week, as a consequence of having told Lyle about the molestation, his fear level never went down below where it was that Tuesday? Yes. Now, in your opinion, Dr. Wilson, if we assume these things are true and that Erik Menendez is accurately reporting how he felt, would the fact that we'll strike that, would the fact that a fear level has gone up, say, on Tuesday and remains at least at that level from then on, does that inform you on the issue of a new level of arousal? Objection, improper expert opinion, and Penal Code Section 29. Sustained as to the form of the question. She's not getting into like the immediacy or imminent danger or anything like that. All right. You described hyperarousal before as a condition with PTSD that is suffered chronically. Correct. You think described it in terms of no, she says you, I think, described it in terms of idle the idle screw is being turned up. Yes. Did you find Erik Menendez's description of being at a heightened state of arousal from Tuesday night on consistent with that concept of the idle screw being turned up, that is, being at a higher level, a constantly higher level of arousal after doing something for which he had been threatened in the past with death? Yes. You had described earlier in your testimony, Dr. Wilson, the notion of cues to prior trauma that can stimulate the arousal system, cause someone to be operating at a higher level of anxiety and fear, correct? Correct. Do the cues necessarily have to do with the behavior of the abuser, or can the cue come from the victim knowing that they're doing something for which they have been threatened with great harm? It came from the latter, as you described it. Now, do you have in mind Erik Menendez's testimony concerning that Wednesday where he stated that he and his brother Lyle were at lunch talking about the situation in a restaurant and Lyle told him Lyle, had told their mother earlier that day, that Wednesday, that Lyle Menendez wanted to see their father to talk to him as soon as he came home Thursday night? Yes. Are you aware of Erik Menendez's testimony that following that discussion, he was very worried because he knew he had not yet told Lyle Menendez of all the threats of death and the threats of punishment that his father had directed at him over the years of the molestation, and moreover, that he was concerned that Lyle might have told their mother what the topic of the conversation was going to be? Correct. Is this continuing state of anxiety, in spite of Lyle's assurances or seeming confident, consistent, in your opinion, with someone who is operating on a high level of hyperarousal and not necessarily dealing with the reality of whether the threat has increased or the threat has decreased? It is. Now, do you have in mind, with respect to that Thursday, first of all, Erik Menendez's testimony that he was too afraid to stay around the house that evening and did not want to be present when Lyle Menendez had his talk with their father? Correct. And is that staying away all that day? I think you've testified that based on your testing, Erik Menendez does somehow, or he shows some elevations in that scale of avoidance and avoidant denial, but not as high as in the intrusive imagining. Correct. So this behavior of not wanting to be around when bad things might happen, an example of avoidance? Yes. Now, are you mindful of Erik Menendez's testimony that when he returned very late that night on Thursday after not being able to locate his brother, he went to his room and was confronted there by his father? Yes. Are you mindful of Erik Menendez's statements here in the trial that after angry accusations by his father that concerning the fact that he had told his father angrily indicating that now Lyle was going to tell the world, when Erik denied that Lyle would tell, his father physically attacked him and basically pushed him onto the bed and was attempting to wrestle with him? Correct. Are you mindful of Erik Menendez's testimony of how terrified he was by this attack and that he had in mind all of the threats that his father had made over the years to kill him if he revealed the molestation? Yes. Now, have you in your mind, Dr. Wilson, and again, for the purpose of these questions, I'm asking that you have the testimony in mind and assume that it's true. Have you in mind the testimony that Erik Menendez is attempting to leave the house in order to find out from his brother Lyle what the conversation between Lyle Menendez and his father was that resulted in his father's angry attack? Yes. And he goes into the room where his mother is apparently watching television or reclining on the couch? Correct. And do you have in mind Erik Menendez's recitation of this exchange of words that he has with his mother, wherein she tells him that she has always known what was going on, that she isn't stupid, and that she's revealing to Erik Menendez her awareness of his history of molestation at the hands of his father? Yes. And do you remember Erik Menendez testifying that his immediate response to her confirming this to him was to scream at her that he hated her? Yes. Now, let's talk about the phenomenon that you've talked about having to do with denial, okay? Mm-hmm. Are people who are involved in these ongoing traumatic situations, is one of the coping mechanisms to prevent them from being so hopeless that they want to take their own life or give up one of denying aspects of the abuse, rationalizing it away, negative things that would make them more, uh, have more ideations of taking their life? Indeed. And in this particular case, assuming that what he told you about these things are true, did you detect that Erik Menendez engaged in multiple denial behaviors and denial like thinking with respect to his mother and whether or not she knew and went along with the sexual abuse that he was suffering at the hands of his father? Yes. Did you determine, based just on behavior of his mother, that Erik Menendez and other witnesses both testified and talked about that there were behaviors on her part that he chose to ignore, that he had scrutinized, may have been evidence that she knew? Correct. Things like checking out his genitals, is that one of the things that you considered? Yes. The fact that she never would enter a room when he was alone there with his father? Correct. The fact that she refused to allow anyone else in the house from ever going near the room when he was alone with his father? Yes. The fact that the two separate tennis tournaments, two different aunts, Joan Vandermolen at one and Pat Anderson at another, were aware that Mr. Menendez had been alone for some period of time in Erik Menendez's hotel room and then announced that Erik Menendez wasn't feeling up to coming to dinner and his mother never asked what was wrong with him or even went to see him. Objection misstates the testimony, assumes facts not in evidence. Sustained. Are you aware, first of all, of the testimony of Joan Vandermolen to the effect that at a tennis tournament, Mr. Menendez had been alone with Erik Menendez for some period of time? Everyone was expected to go to dinner together, and then Mr. Menendez announced that Erik would not be going to dinner? Objection assumes facts not in evidence, misstates the testimony. Overruled. The objection is overruled. That was the testimony. Witness says yes. Ms. Abramson says, all right. Are you aware of any behavior on the part of Mrs. Menendez where she showed any concern or went to Erik or tried to check out his physical condition? No. Are you aware of testimony? The court says, all right, this is beyond this witness's purview here, so let's get to what it is that you want to ask him, not what he's aware of. Ms. Amerson says, now, assuming hypothetically, as we are, that Erik Menendez had been engaging in this rationalization and denial of his mother's duplicity in his molestation over the years in describing, first of all, are you mindful how he described how he felt and what he thought after he realized that Thursday night she knew all along? Yes. And did he describe a highly agitated and upset emotional state? Yes. Did he describe feelings such as intense betrayal? Yes. Would such feelings, assume they are true, be consistent with someone who is being faced with very unpleasant realities that he had been trying to deny knowing for many years? Correct. Now, you recall also, Dr. Wilson, that you have testified about this concept of learned helplessness and how it impacts on the failure of people in abusive relationships to walk out of those relationships. Yes. You've indicated that one of the reasons why people in abusive relationships don't leave them is because they don't see any allies. Yes. In this particular family, based on the information that you have been given from both Erik's statements and testimony, and that of other witnesses and observers of the family, when he learned that his mother knew about all those years, did that make that she knew about the abuse all those years, did that make it even less likely that he would be able to escape from the molestation of his father? Objection calls for speculation. Sustained. Ms. Abramson says, you had talked about the fact that in this particular family, enforcing the development of severe PTSD symptoms in Erik Menendez was his isolation from his mother, enforced by his father. Do you remember that? I do. Would the knowledge, hypothetically, that his mother knew all along what was happening to him and had never helped him make him feel even more isolated and alone? Objection calls for speculation, improper expert opinion. Sustained. In your opinion, Dr. Wilson, was there a significant, we'll strike that. In your opinion, assuming the facts to be true, was the fact that Erik Menendez learned on that Thursday night that his mother knew all along of significance in the demonstration or exhibition by him of symptoms of PTSD from that point on? Yes. Can you explain what was the significance? Surely. The significance was that at that moment in time he experienced a betrayal, that his mother was not available to him, that she knew about the abuse, that she hadn't done anything to stop it, and he at that moment feels a deep inner sense of betrayal because he had hoped for so long that she didn't know and that there was that possibility of a special relationship with his mother. So that sense of that connection with his mother is now gone. And does that, you recall Erik Menendez testifying that along with that sense of betrayal, he became fearful of his mother because he, I think you said, didn't know who she was anymore? Yes. And if we could just move ahead for a moment, when he comes to believe that evening that his father is going to make good on the threats that he has made because of the revelation of the secret, he indicates that he believes his mother will go along with a plan to kill him because he has now heard that she really never cared about him. Yes. So, does this interaction with his mother, beyond causing betrayal, cause a level of fear of harm from his mother that he would not previously have experienced? Objection, Penal Code, Section 29. Sustained. Ms. Abramson says, would it be consistent with someone who is susceptible because of PTSD to fear harm under this fact situation from his mother because of her knowledge of his trauma inducing situation, even though she never specifically threatened to kill him? Objection, Penal Code, Section 29. Sustained as to the form of the question. Ms. Abramson says, let me think it through for a moment, Your Honor. Maybe I can say it in a way that it won't be objectionable. I have 15 minutes to figure this out. Okay. I guess it's getting near the end of the day for them. She's got only 15 minutes of questioning left. She asks, is there a particular susceptibility on the part of people with PTSD to feel threatened? Yes. Is there a particular susceptibility on their part to fear that any harm that hostility aimed at them can turn to lethal harm? Yes. Is a situation where someone with PTSD has been threatened with death by a person who has been traumatizing them, if it is perceived that that person has an accomplice also interested in the death of the victim of the trauma, is it consistent with post traumatic stress disorder that the victim of that trauma would fear death at the hands of both the prime mover and the accomplice? Objection, Penal Code, Section 29. Sustained. Well, we will get back to this, Your Honor. I am not understanding. Sorry. Court says your next question. So she's not quite understanding why everything keeps getting sustained. She says, is Erik Menendez's fear that his mother would be willing to kill him, which he related in court, consistent with someone who has PTSD? Objection, Penal Code, Section 29. The court says, at what time are you referring to? Ms. Abramson says, at this time, this Thursday night. The court says, okay, are you asking the witness to assume that the defendant testified about something relating to fear at that time? Yes. The court says, what are you asking? Ms. Abramson says, I am asking if Mr. Menendez relating that he had fear of his mother at that time because he didn't know who she was and knew how image conscious she was and knew that his father was angry over the revealing of the secret. I am asking if that fear that she would participate in harming him is consistent with someone suffering from PTSD as a result of being traumatized by the very actions, the secret about which they have revealed. The witness says the answer is yes. Mr. Khan says, I would object, Your Honor. Penal Code, Section 29. Sustained, the answer is stricken. It goes beyond the witness's purview. Well, I'd like to be heard on that, Your Honor. Okay, says the court. Can we do it now? Okay, we'll take our recess. It's 4:15, and we'll resume tomorrow. At this time, we will talk to the lawyers about some matters. Don't discuss the matter with anyone. Don't form any final opinions about it. Don't look at any news coverage. We will see you back here tomorrow at 8:30. The jury exits, and now we have some arguments outside the presence of the jury. The court says, okay, the jury has left. Several observations. One of them is that you tend to combine facts or statements of facts by the defendant in his testimony with descriptions of his mental state without distinguishing them. And it's not for this witness, to accept or reject the defendant's testimony as to the facts. The only purpose is to deal with the defendant's mental state, and I don't recall in this particular instance whether or not the defendant described a particular reaction of mental state in regard to his mother's conversation with him. If he did, then the only extent of inquiry would be whether or not that reaction was consistent or inconsistent with the person suffering from PTSD, period. I know, but, says Miss Abramson, and he cuts her off and says, for you to editorialize and combine it with all the facts you like about the case and throw it all in there in an argument fashion, that's improper. Miss Abramson says, well, the point is to say, otherwise, I will just be asking, is fear consistent with PTSD? Is fear consistent with PTSD? The question here was whether his fear of his mother, in view of these facts of the revelation in that discussion, were consistent with PTSD. I mean, now he fears, he testified that Thursday night he believed that both of his parents would kill him, and he was afraid of his mother because he didn't know who she was. She had betrayed him. I mean, I can take it three steps further to when she's screaming, I hate you, I wish you had never been born, and calls him a bastard and chases after him to the guest house. But I think the important thing is whether or not someone who is anxious or easily frightened and hyper aroused, which is the PTSD person that we have described here, whether it's consistent for them when faced with this kind of betrayal, when faced with the acknowledgement by their mother that she knew to fear that she wants to kill him, that she knew to fear that she wants to kill him. I mean, the crucial fact here, the court cuts her off and says, all that stuff really is for the jury to decide, not for this witness. The only issue for the witness to analyze is the reaction of the defendant, his emotional state, nothing else. As to why that reaction occurred, whether it was what one would expect or not expect, those are things for the jury to resolve, not for an expert witness. Ms. Abramson says, all I am asking is it consistent with fear of his mother following this? These facts consistent with PTSD? That's all I ask. The court says, then you go beyond it with the editorializing as to why he acted that way and throw it all into the mix. Ms. Abramson says, I will try to do it more simply. The court says it is well beyond his expertise, number one. And number two, really, these are issues for the jury, not for the witness to analyze. Do the people wish to be heard on this? Mr. Khan says, Your Honor, we would object to the manner in which counsel was asking the questions in several respects. One is the way that she is asking that what appears to be excessively leading questions, argumentative questions, in which she summarized some facts in a list form. She gives a list considering the testimony of Erik Menendez, what he felt, and she goes through a long laundry list, which is really just an argument for the jury. It is one thing to direct a witness's attention to a specific area. It is another thing to make a long argument on behalf of the defendant just for the purpose of having the witness then say yes in agreement to everything counsel is in effect testifying to, because we are really listening to the testimony of Leslie Abramson more than we are listening to the testimony of Mr. Dr. Wilson. He ultimately says yes in confirmation of what she's saying, but 95% of the testimony is coming out of her mouth and not the witness's mouth. So I would object to the counsel being permitted to ask leading questions such as that. If counsel wishes to direct the witness's attention to a specific area, I would ask that the court require her to simply say, you heard the testimony of Erik Menendez concerning his response Thursday night to his mother's remarks. Is that consistent with PTSD? That is the first point. I don't disagree with him there. Like I actually agree with him there. I think her questioning got a little too specific with stating facts, and I don't disagree that she was doing more of the testifying than the witness itself. So I kind of get it there, but she's also in a bind because when she does try to ask the question the right way or any way, she gets objection. Section 29 or whatever. She's constantly getting objections. She's constantly getting, obstructions in her way as she's trying to get this testimony out. So I get it. And she's got all these different rulings from the court saying, well, you can't do this and that and the other thing too on her mind. So she's got to try to fit it into this little window of how to get it in. And it's not working at this point. She's getting yelled at here by both the state and the court. He says that is the first point. The second point, Your Honor, is I also object to the counsel repeatedly making side remarks to the jury to hear. She has said a number of times things along the lines of, well, I've only had 15 minutes to think about this, and well, let me see if I can get there in another way. That's just her talking out loud. I'm sure she doesn't even think or realize that she's doing it, and I'm sure it's not intentional. All of these remarks, which basically explain to the jury her state of mind regarding the asking of these particular questions, either perhaps that the court has put her in an uncomfortable position, that the court has changed the rules of the game 15 minutes ago, and she hasn't had an opportunity to assess that situation. Well, that kind of is what happened. Or that the information is, in fact, admissible. We all know it's admissible, and it's just a matter of asking the right question in the right way. There is an argument, perhaps, what she is getting at is not in fact admissible. So I object to these little side remarks that she makes, which suggest to the jury various things concerning what's going on in the courtroom. I would also object to the last answer given by the witness. The court asked the witness to refrain from commenting upon the fear of the defendant at a particular point in time. I objected to the last question asked by Ms. Abramson. The court inquired of Ms. Abramson, "What do you mean by that?" And then she gave clarification in response to the court. She was talking to the court at the time, explaining to the court what she was trying to get at, and it was a response to a very argumentative question by counsel in which she once again went through a long list of things in a very argumentative way, which supported her position that the witness then blurted out yes in response to that, when I think we were all waiting for the court to be given an opportunity to respond to counsel's question. So I would ask that, again, the witness be admonished to refrain from blurting out answers when the court is still considering the admissibility of questions that counsel is posing to the witness. The court says, okay. Regarding the reference to facts, I think counsel is much more mindful of the recitation of events described by by the defendant in his testimony than the jurors are, and just reference to something that occurred on Thursday in a conversation with his mother would not be sufficient to guide the jurors to the nature of the inquiry. So I believe the inquiry should be more focused on whatever the fact scenario was, so long as the fact scenario is related to a reaction articulated by the defendant in his testimony. If there was no reaction by the defendant, he didn't say he was in fear, he didn't say he reacted in a particular way, this witness is not on the witness stand to fill in the gaps and tell us what the defendant really was thinking at a particular time. All he is here to do is to testify as to whether or not the state of mind of the defendant at a particular time in which the defendant described that state of mind was consistent or inconsistent with the post traumatic stress disorder that he has diagnosed and nothing more. Therefore, the fact recitation is only a basis for the question to describe the mental state ascribed by the defendant in his testimony. The description of the facts don't have to be and shouldn't be in an argumentative fashion and will not be permitted to be in an argumentative fashion, and also are not to consume a great deal of time. It's just to focus the jury on a particular time frame in which the defendant said he had a particular state of mind or mental state, then to ask the question whether it's consistent or inconsistent with that diagnosis and move on to the next question. So, counsel is not to argue their case and to ask argumentative questions or go into unnecessary detail of the facts just to focus the jury on the fact situation that is the basis of the testimony of the defendant regarding a particular mental state. So, what I am saying is the people's objections is too broad, but there is some merit to it. That the defense is really trying to regurgitate detail of the defendant's testimony in words of counsel rather than letting the jury refer back to the actual testimony. So he's got a point. He's like, you need to balance it. Like, you can't recite everything, but you do have to recite some things because you have to be specific enough so that the jury and the witness knows what specific event or facts of the case you're talking about. So, counsel should refrain from going into great detail on those facts with the understanding that great detail shouldn't have any significance to the witness. The witness is analyzing the mental state of the defendant, not analyzing the fact scenario. It's not for the witness to tell the jury how he analyzes the facts as to whether these facts did or did not produce a certain mental state on behalf of the defendant, just to explain for the jury whether or not the mental state as described by the defendant was consistent or inconsistent with post-traumatic stress disorder. I really want to know why there's so many limitations on this particular witness's testimony and how he can't talk about specific events of that happened in Erik and Lyle's lives to relate it back to PTSD and how he thinks that, there are symptoms. These are symptoms and signs that they might have been displaying PTSD for many years. I don't understand why they can't get into that with this particular defendant. It must have been a ruling. Maybe the state did a motion in limine to limit this particular witness's testimony somehow. I don't know why. Not really sure. Maybe I'll do some research on that after this episode, and come back to you guys. But the point is, experts are supposed to talk about the things that he's limited to talking about. So I'm really confused as to why it's so hard to get his testimony in, because really these limitations shouldn't be as stringent as they are when it comes to expert testimony. When you're the defendant trying to put on a defense, you have a right to put on a defense. But the state is blocking that right because they keep trying to block everything that has to do with the abuse or the PTSD or anything that has to do related to psychological effects of abuse. So there's that. Ms. Abramson responds, Judge, it just occurs to me in listening to you, though, that I think that may be too limiting because keeping in mind the language from Eris, the expert is entitled to testify how the experience of being battered person affected the perceptions at the crucial times, and that's not just simply validating. I mean, what the court's narrowing of that would mean is that a defendant has to be they have to be their own psychoanalyst. They have to know precisely what their mental state is or precisely what their thinking is at a particular moment in time, and that doesn't happen to be true of most people. The court says, well, we are not talking about most people. We are talking about this case. She says, my client. The court says, we are talking about this case and the testimony that has been presented by the defendant. Bear in mind, the court has previously ruled that the testimony of Dr. Wilson is offered to corroborate the testimony of the defendant as to his state of mind at the time that events occurred. That is the sole purpose of it. It's not to analyze the fact situation and to go through and explain. Samerson says, I'm not asking for his. The court says somebody did this or didn't do that or did or do any more than to establish or to do any more to establish that if his testimony is believed by the jury that the description of the mental state of the defendant is consistent with that of someone suffering from PTSD, put together with the abundant evidence offered by this witness over several days regarding the symptomology of post-traumatic stress disorder, the hyperarousal, and all these other things that he has already described, that's all there. The jury has it. And now, Ms. Abramson says, all I think I should be entitled to do, apart from what the court is saying, which is to validate the specific words of the defendant that yes, that's consistent, is to have the witness be able to tie together that symptomology of post-traumatic stress disorder and the defendant's both description of what he was thinking at the time of the offense and the behavior that he exhibited, and that goes a little beyond. I think that fulfills the Eris description of how, if you will, the disorder affects perception and goes and is slightly different than simply saying, if he's saying he's scared at this point, consistent with post traumatic stress disorder. For one thing, at the crucial times, I should be able to ask him why it's consistent rather than just have this. I mean, the only reason I am doing what I consider to be a very cumbersome and meaningless form of examination where I am doing all the talking is because I want to live within the constraints of the court's ruling. Exactly. Like she's in this little box here. She can't go outside of it, and she's having a really hard time trying to get the testimony in. So she says that she's trying to live within the constraints of the court's ruling, that he has to base his testimony on precisely what the defendant testified to, assume to be true, and limit it to is that consistent with PTSD. Otherwise, I would be asking the witness, well, what did the defendant testify to about Wednesday that's consistent with post-traumatic stress disorder? And then we might get into this wide range thing that the court doesn't want to. So I am trying to stay within the rules, and I am getting criticized for staying within the rules, on the one hand. The court says, we are beyond that because I told you how I want you to proceed with reference to the facts. And I think I'm doing that, says Ms. Abramson. The court says, okay, so we shouldn't be back to a discussion of that. Ms. Abramson says, okay, but I think that at the critical moment, and I have just been doing it that way for the preliminary stuff, but at the critical moment of Sunday, I should be permitted to ask the witness why, what it is about the behavior of the defendant he said he engaged in and about the feelings that he indicates he had that is consistent with post-traumatic stress disorder. I mean, so that he can validate his own opinion and not just be a little parrot saying yes, yes, yes. Now, with respect to the specific concerns about the fear of Mrs. Menendez, it happens to be a complicated set of facts at this point to go from what was said between her and my client and then his state of mind about it, which was now to be fearful of her, fearful in the context of his having revealed this secret and the threat of further revelation of the secret, given the fact that he now finds out that she knew, that makes him afraid of her. That's what he testified to. The court says yes, that causes the witness to then say to the jury that the defendant was afraid of his mother, and that is not something he is permitted to say. Miss Abramson says no. It's to ask him if fear of his mother at that point, under those circumstances, is consistent with PTSD. That's all I'm asking. That's no different than anything else. The court says if the defendant expressed fear of his mother at that time, was that consistent with post traumatic stress disorder? I told you that would be a permissible question. Oh, okay. The court says if he said that, I don't know if he did or didn't, if that's what the defendant said at the time, would that be consistent? What is the people's position in regards to the witness being asked? I assume at the time the defendant killed the parents, is this state of mind expressed by the defendant consistent with PTSD? Mr. Khan says, well, I think that the problem with that is that it's going to depend upon the answer given by the witness. We don't know precisely what he's going to say. What I anticipate he is going to say is he is going to get into that which is prohibited under Penal Code Section 29 in People versus Harris, and he's certainly going to come as close as he possibly can to doing so. So I think that until we know precisely what the answer to that question is, I don't think that we can really analyze it in a vacuum. The court says, all right, well, I think it's an appropriate question. As to the answer, I assume he will refer to things such as hyperarousal and any other phraseology that he has described here, and that those reactions are consistent with the diagnosis. And if he doesn't express any opinions regarding the defendant's belief that he was in danger, that he was in imminent danger, but just is confined to a description of the symptoms is displayed by the defendant as he described them in his testimony, then it would be permissible. And you keep referring to the Eris case and what it says. It doesn't talk about this testimony and this evidence. That's the defect of Eris. And there is really, from my looking at the cases, perhaps counsel have found numerous other cases on the subject. There really aren't any cases that talk about this particular subject as to the extent of testimony in this case. Ms. Abramson says, see, Judge, if they had reversed Eris like they should have, then they could have given specific direction back to the trial court about how to allow that testimony in, and we would have more guidelines here. They say it was wrong to keep it out and it was harmless error, so they didn't have to be any more specific than that. The court says, that's why I said we don't have any guidance. Ms. Abramson says, but I do agree that logically, there is, if it's admissible, then that's only a minimal. There are only so many ways that you can use the English language to get in what they say is admissible and permissible. And even though logically it may seem to be invading Section 29, I think that it doesn't. The court says, well, my real concern is that there not be a violation of Section 29 because if push comes to shove, I think Section 29 has more validity and more staying power than the little language that we're talking about in Eris. Ms. Abramson says, well, the court may recall that in the last trial, we stayed away from Section 29 and the people opened it up on cross. So we'll see. The court says, okay, well, Anyway, I think we have covered the field at this point, Ms. Amerson says. Right? The court says, as far as the next portion of the witness's testimony, anything else that counsel want to discuss relating to this testimony or any other events that are upcoming? Ms. Towery says, yes, Your Honor, just very briefly with respect to the witnesses that we're calling this week, Peter Cano is not able to come to Los Angeles. I'm sorry? Peter Cano was not able to come to Los Angeles this week, so he is scheduled for next week. Also, Mr. Khan indicated in response to our inquiry as to his estimate as to of how long his cross-examination would be of Dr. Wilson. Initially, he said 2 days, and then he said a half a day. So, assuming that his estimate is in fact closer to 2 days than a half a day, I have been trying to schedule some local witnesses to fill in the remainder of this week. We still have Marta Cano and Annie Cano, but I am also seeking to schedule Barbara Zussman, Tim Custer, Doug Doss, Norman Poles, and Noel Nedley is scheduled to testify here on Friday for the defendant. Who is Custer? Says the court. Ms. Nahara says he wasn't on the list. Ms. Towery says Tim Custer is an impeachment witness for Jamie Pisarcik. He testified at the last trial. The court says, well, as far as Zussman is concerned, her testimony, as I recall, was contingent upon there being some dispute. See, he remembers these witnesses, but yet he cannot, for the life of him, remember any of the abuse that happened in the house. He just seems to have forgotten all of that and thinks that it is a lie or something. I don't know. He has forgotten all of those experts from the first trial that have testified that this was abuse. This is like one of the casebook studies of abuse and probably one of the worst kind, one of the worst casebook studies. Anyways, so the court says, well, as far as Zussman is concerned, her testimony, as I recall, was contingent upon there being some dispute. Ms. Abramson says, I don't believe so. She was a symptom witness close in time. She is a 1989 witness. The court says, yeah, that might very well be, but it might have also been my ruling that there was some. Let me find my materials on that. Ms. Abramson says, I was under the impression, I might be wrong on this, but I thought the court's ruling vis-a-vis dispute, it doesn't say dispute, it says Barbara Zussman. She testified about the defendant, Erik Menendez, being, the court says, what are you reading from? Ms. Abramson says, I am reading from the transcript. Pages blah, blah, blah. Don't ask me what volume, Judge. He says, okay. 35 what? She repeats it. You didn't say she was contingent. You said that she testified about being dyslexic. Quote, I don't know what relevance that would have. If it has any relevance, I would have to hear it after the testimony of the expert. End quote. And I think she testified that Mrs. Menendez told her the defendant was dyslexic, but she also testified about having learning disabilities even at 18. The court says, okay, but if there is no dispute about that, then there is no reason to have her come in to testify. Ms. Abramson says, well, I don't know how we would know there's no dispute until after Dietz testifies. The court says, no, at this point, we're on your case, and if there is no dispute about it, there is no reason to have them come in. This witness come in, and this same with Doss and the Goldsmiths. All these witnesses, their testimony is only contingent upon there being dispute regarding the basis of the expert witness's testimony. Ms. Abramson says Goldsmith saw acts of violence. Also, Your Honor, and whether there is a dispute or no dispute, I think that that kind of behavior is admissible. The Goldsmiths also, the court says, well, that's subject to a further hearing. Right, says Ms. Nahara. So we're going to have more arguments about more stuff later on. Court says, we have had some testimony from family members about acts of violence, and at some point there has to be an evaluation as to the extent of it. So he doesn't want all of it in. Basically, he wants to minimize it so that it doesn't seem so bad, right? Ms. Abramson says Dr. Doss's testimony had to do with, again, you didn't make it contingent on a challenge of credibility, Your Honor, That was what you did with the witness. You said we couldn't call unless their credibility was challenged. Mr. Doss, who is a 1988 coach of Erik Menendez, describes symptoms of PTSD. The court says, right, if a witness comes in and says the defendant spaced out on a tennis court and that's all he's going to say, it doesn't seem as though it's worth that testimony of having the witness coming in to say that if it's not in dispute. You have had the expert say it. If the people don't dispute it, then why do we need to have this testimony? She says, because we would like them to see some real live people and not have it dependent on Dr. Wilson. There are other witnesses that could have said a great deal more, but Your Honor said that they were not close enough in time. We sort of get whip snapped here, where the one who knows less are closer in time, and the ones who saw far more are far too away in time. The court says again, the focus is mental state at the time of the crime, and these mental witnesses, so the witnesses are mental, that's what it sounds like, are only the basis for the expert testimony, and if that testimony is not challenged, then there is no relevance to it. It really doesn't prove anything, and it's subject to 352 objection, which would be sustained. So I am just telling you that there are some witnesses who are on your witness list who, based upon the nature of the examination of Dr. Wilson, might not be called. So I am just giving you notice of that. But those were witnesses who were mentioned by Ms. Towery, so it won't affect our schedule this week. Ms. Abramson says, I could have sworn she just mentioned Norman Pulse and Barbara Zussman. Ms. Towery says, I said Pulse and Doss and Zussman. The court says, all right, Marta Cano, you said was here. That's correct, says Abramson. Court says, and her son is here. Ms. Abramson says, that's correct, Your Honor. That'll be Andy. Um, Ms. Towery says, right. The court says, it seems to me that those witnesses plus Ms. Towery adds Noel Nedley. The court says Noel Nedley and this Tim Custer could take up much of that time. So you are talking about two witnesses, Poles and Zussman at this point. Ms. Towery says, and Doug Doss as well, Your Honor. And Doug Doss. Okay. But don't have them come in until we have further hearing on them. I assume the Canos are here in town. Is that right? And will be testifying after Dr. Wilson. Mr. Khan says, just getting back to my remarks about counsel's remarks in front of the jury, I think counsel should be admonished because it creates a situation where I am forced to object to every little remark made by counsel, and I don't want to be forced to be in the position of objecting. And just, uh, I just ask the counsel to be admonished to refrain from those remarks. The court says, I forgot to refer to that in my response to Mr. Khan. Ms. Averson says, first of all, Mr. Khan misheard. The court says the minutes had to do with 15 minutes before we recessed for the day and not 15 minutes to prepare. Most of the remarks of counsel are just exactly right, says Ms. Abramson. She was just like, it was a thought that she spoke out loud. The court says it's just innocuous, and none of those that you described, really, Mr. Khan, were of any great moment. I didn't interpret those that she made as efforts to question the court's rulings or to infer to the jury that there is something that they weren't hearing. Believe me, if I felt that, I would be the first to react, not the last. But I just didn't see that. I don't infer that from her remarks. Counsel have to be provided with an opportunity to express themselves their own way. Everyone has their own personality, and I am not concerned with those remarks. They really were innocuous, and that's how I react to it. Believe me, if I see otherwise, I'll react to that as well. And that is the end of January 22nd, 1996. With respect to the Menendez trial. So there you have it. We have a lot of back and forth with what can and can't come in regarding PTSD and how you can word your questions and how you can frame that and how you can get the facts in, but not really the facts, just the state of mind. And it's just all a big mess. Why do we have so many limitations on this judge? Why can't we just let her ask the questions? If we want to get to the truth, if we want to find out what's happening in this case, why don't we just ask the darn questions instead of limiting her to this tiny little box where she can't do anything? And then when she does try to limit it to that box, you yell at her. It's ridiculous. So, I mean, it's crazy. This whole case is crazy. And the way that the judge and the state have basically partnered up is crazy to me. But that's what I'm seeing. Anyways, we will continue on with Thursday. No, Tuesday. Yeah, Tuesdays and Thursdays. So Sunday, Tuesday, and Thursday. So this is your Tuesday episode. Thursday, you will be getting part 80. And Dr. Wilson will still be on the stand because we haven't even gotten to cross yet. So, and it's not going to be half a day. Spoiler alert. So we'll get to that when we get to it. Thank you guys so much for watching, and I will see you in the next one. Take care. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.